Wake up, really gonna rise with the sun. Step 2, get some good, some food in you. Step 3, think real hard about what you wanna be. Step 4, everybody just do your thing.
Wake up, today's gonna be a good day. 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 Yo, set your affirmations, aspirations. I got shit to do, the aftermath of preparation. Good food, good mood, blood in circulation. One step at a time, yeah, that's how you make it. Set a goal you control and the steps you take them. I try to pick one thought, have some concentration. And if I make a mistake, it's called education. I try to do this every day, call it replication. Wake up, today's gonna be a good day. 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 So life ain't easy, yo, I think there's a reason though. Ups and downs, just like every different season, yo. Sometimes I'm high, other times I'm barely breathing, though. I always gotta fight and hide from the demons, yo. Negative thoughts are poison, they rot. Head full of flaws, so here come the clouds. They'll never stop unless I can swap all the bad for the good in my head when I'm lost. Yeah, so I'ma fake it till I make it. Positive thoughts are overtaken, I got patience. One day at a time is how you operate a cadence. A flow, you grow, you show yourself a foundation. Stay away from all the shit that causes temptation. I know that I like to do it cause it's sensation. I live my life in my head like a narration. Don't expect greatness, do my best, man, I'll take it. Wake up, today's gonna be a good day. 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 Wake up, today's gonna be a good day.
Wake up, really gonna rise with the sun. Step 2, get some good, some food in you. Step 3, think real hard about what you wanna be. Step 4, everybody just do your thing.
I have a question for you. If you woke up this Friday morning and you looked in your bank account and there was $10,080 magically there, and you're like, wow, that's amazing. But the only stipulation is you have to spend it all in 1 week and it'll be gone. And then the following week, you'll get another $10,080 deposited, and so on and so on. You can spend it however you want. Or if you don't spend it, it disappears. Would you spend every cent every week, or would you allow it to be wasted and taken away from you? Well, guys, this Friday, you're going to wake up and there's going to be 10,080 minutes that God has given you for the next week. And you can spend them however you want, or you can simply waste them. Guys, I highly suggest that you spend every minute of next week doing amazing things, and don't allow 1 minute to be squandered, because you never know when God won't deposit another 10,080 minutes in your life, guys. Go out and live a great life.
Welcome to the Bullhorn Betty Coffee Club.
As you wake up in the morning, you want to find the latest, greatest information about criminal cases and have an intuitive conversation about the suspects associated with these cases. Head over to the Bullhorn Betty channel on YouTube. Get breaking news right here on the Bullhorn Betty channel. Welcome to the Bullhorn Betty Coffee Club. Enjoy your stay and enjoy your day.
Saturday. It's nice to see everybody. We don't typically come live on Saturday, but in light of the information from yesterday, we have decided to come live. A couple things that are I'm not sure if this whole recording thing is starting to jam me up over here. Hold on a second. I don't know if I can undo this. Probably can't. We might be stuck. So if my voice and my lips don't match my speech during this live, I'm sorry. I'm doing some other stuff behind the scenes to record my lives, and it's supposed to make it better, but it doesn't look like it is. But we'll see what the finished product is. So bear with me. Bear with me, folks. It's going to be one of those crazy days here on the streets of YouTube. So Brian Coburger, for just those that are coming in new to this case that don't really know what is going on, you've heard about it, but don't really understand what is going on. So there were 4 University of Idaho students that were slain in their sleep. They lived on the outskirts of the University of Idaho. They were killed November 13th, 2022. In the early morning hours of 4 to 4:20 in the morning. He wasn't identified immediately. He had seemingly no connection to the victims. And around November 29th is when a Wazoo police officer that monitors the school, hired by the school, came across a white Elantra in the Steptoe Apartments, which was identified as Brian Coburger. Brian Coburger's was named a suspect December 30th, which Olivia and myself, is this thing good? Let me just, Emma, I'm just going to say good morning to a few of you. Emma, Christina, Slim Skittles. So that's all I need to do is put Slim Betty, and I'm just Slim. Is that how it works? That was easy. Sheila, it's nice to see you. The Real Me Too. TY413, it's nice to see you as well. Lady O. Tammy, Julie, it's nice to see you. Pen 1010, May, Toshi. Candy Apple, nice to see you, honey. I haven't seen you in here in a while. Jessa Love. Patricia. Who else do we have? Kathy. I am Team Summer. Melly Joe, Pittsburgh Nurse. Mike, it's nice to see you. 456 Casino. Somebody's gambling. Are you gambling on me? I'm a winner. Winner, chicken dinner. Oh, Lord. Nana, Miss Margaret, it's all nice to see you. Miss Meadows, it's nice to see you as well. Riding solo. I've been riding solo for a couple years, and I gotta tell you, sometimes it's nice, sometimes it's not. You know, there's always benefits. There's always pros and cons to everything. There's always pros and cons to everything. So it's nice to see you. We're going to go over some stuff with Adam Fravel first, and then we're going to kick off right into Brian Coburger. We got a lot to go over with the Brian Coburger stuff. My opinions, your opinions, and what is being written in black and white. And we also, I don't know how long this live is going to be. Can you guys let me know, am I jamming up on your end as well, or is it just on my end? Because what I've got is StreamYard has this like beta testing going on for this recording. So it records you after, ask all this to stay. So it starts recording you whenever you're live. Right? And then it's supposed to produce this nice, better quality thing, but it seems like it's jamming me up on this side. So anyways, Courtney, it's nice to see you. But I just want to see if it's also that way, or if I'm coming in clear and it's not hiccuping or jamming up on your end. So I'm just going to wait because it takes about 20 seconds. We have a 20-second delay. And then we'll get started. I'm trying to decide whether we should read the language of letting go. I didn't get a chance to read it, but the title of it, Let Go of Guilt, kind of really sounds good. No, I don't think Brian Coburger is a heartthrob at all. I mean, he does not, he's just not my type. But there's a type for everybody, right? So just because he's not our type doesn't mean he's not somebody's type. Obviously, he's getting some love letters. Maybe it's his popularity. I don't know. I don't know. Clear? Oh, perfect. Perfect. I love it. Okay, I just wanted to make sure if it's on my end, I'm perfectly fine with it as long as I'm not hiccuping on your end. So June 10th, which today is June 10th, guilt is a rock. It lies in the pit of our stomach and keeps us awake at night. We can all identify with that. All of our muscles work overtime just to carry it around, and yet we still hold on to it. Yesterday, you stumbled. That was yesterday. But you also righted your wrong and vowed to do better today. So why are you still carrying the guilt around with you? If you're in recovery, you probably did some terrible things before you got sober. I can identify with that. How can you ever move on? But you got sober. You made amends. What happened yesterday belongs to yesterday. Today, you can let go of your guilt and relax in peace that comes from walking the path with heart. Have you made a list of people you have harmed and made amends to them? As suggested in the 8th and 9th step of the 12-step programs. That's an excellent way to begin clearing and releasing guilt. If you're not in a 12-step program, there are other options. Most religions offer rituals to clear guilt. Sometimes we've taken all these steps and we're still feeling guilty. What's wrong? We're hanging on to our guilt. We're being hard on ourselves. You will find it easier to relax and flow through experiences of your life if you let go of what's weighting you down yesterday's guilt. God, today I give you all of the guilt from my past. Take it from me and allow me to begin a fresh start now. Help me make amends I need to make. Then let me allow to let go of my guilt. Okay, so there you go. And I thought this was interesting. Like I said, this was the first time I read it to you guys. We read it together. I didn't read it. Sometimes I read these before I come live to decide whether I'm going to read the message or not. This one, I like the title. We read it. And many of you that come here and visit with me know my story. I talk about my story. I talk about it a lot. And it's not, to get, it's to inspire others. It's to inspire others that you can literally wake up today and have a fresh start on a new life. You just have to want it. And it's all about how bad do you want it? The people that want it really bad wake up today and do everything they can to start that fresh start. Whenever you have done a lot of things, whenever you have drugs, alcohol, dependency issues, you've had abuse and other things, that stuff weighs you down. It makes it hard to move forward. It makes it hard for you to overcome. So you're required to work 1,000 times harder than everybody else. It's all about how much you're willing to put into yourself, right? You have to make an investment in yourself. You have to make an investment into yourself. So I hope you all do that today. I'm not meaning it that way. Okay, well, I'll let you guys handle your business. Just make sure you keep it respectful. Make sure you keep it respectful. That's the only requirement here, is to be kind to one another. Your positions, your opinions, they all matter. They're yours to have. Nobody has a right to tell you how to walk, talk, think, right? Most of us are here in America, and we're afforded our rights just like everybody else. So utilize them. Don't allow them to be taken away. Don't allow them to take away. So getting started on our morning this morning. As I said, we're going to get started with Adam Fravel. I keep wanting to call him Fravel because it rhymed with travel, right? We followed the travel of Adam Fravel. It just rhymed. It was clicky, right? Well, we realized that we were pronouncing his name wrong, which is often here on the Bullhorn Betty channel, right? No big deal. Kayla, it's nice to see you. Sonia, it's nice to see you. Coffee is my curse word. It is nice to see you as well. So here is, and I just want to give a shout out to Joan. Joan's been making sure I've been updated on this case. So big shout out. I don't know what her name is on here on YouTube, but I do want to just give her a shout out. Thank you. for getting this to me. A lot of people send me a lot of stuff daily, such as Spirit of the Sword. There's a lot of other creators and other people that watch our channels that help this channel immensely behind the scenes. And I just want a big shout out to them. I know I don't always come out here and use your work because we have 1,000 other things going on. I don't always respond to you. I don't always say thank you. So I also want you to know while you guys are listening that I do get them. I am very thankful, and I do appreciate all the hard work and keeping us updated here on the Bullhorn Betty channel. This is one of those emails that came to me, and this is related to the history of Adam and some of the stuff that was pretty shocking. So I thought this would be great. Again, we may have, because it's not on YouTube, we may have a commercial up front.
I have plenty of worries in my
We
life.
always do. And
I have a hard enough time making breakfast in the morning. There's one thing I don't have to worry about, my furnace and AC. Never even enters my busy, high-performing mind.
Here today to announce my office filed charges against Adam Taylor Fravel for the murder of Madeline Kingsbury.
After months of unanswered questions, the search for Madeline Kingsbury is over. But the case against the father of her children, the man accused of killing her, is only just beginning. Good evening and thanks for choosing ABC6 tonight. I'm James Wilcox. Robin Wolfram is off. Adam Fravel is now charged with 2 counts of second-degree murder, with the potential of upgraded charges still on the table, according to the prosecutor. The newly released criminal complaint includes a long list of details that until today were not public. That includes new evidence Fravel may have been physically abusing Maddie on a routine basis. ABC6 News reporter Jordan Sansom spoke with domestic violence experts today about what made Maddie's situation especially dangerous.
Right?
Jordan?
It doesn't surprise me.
James, according to the criminal complaint, Maddie's relationship with Adam was fractured and she was looking to move on. Experts say this is a dangerous time, and when you add her 2 kids, it makes things more complicated. According to the criminal complaint, Adam and Maddie were on an on-again, off-again relationship for 7 years. Domestic violence took a toll on their relationship, leading up to Maddie's death.
Whenever people say, well, why doesn't she just leave? One of the first things I say is because at that moment, she is in the most danger.
Incidents of Fravel physically
And we agree,
hurting
it's
Maddie
the most
are
dangerous. But if they're
listed
going
in
to kill you,
court
they're going to
documents.
kill you.
A friend of Maddie's saw Fravel strike her while on FaceTime. Some violence allegedly happened in front of her children, according to this text message conversation between Fravel.
I'm not sure what's going on.
Violence is all about power and control, and there's a
Give me
pattern
just a
of
second,
abusive
guys.
behavior
There's
that
something
takes
going on
place
here.
over a period of time, and so it's very subtle.
Experts say people can stay in a
Give me just a second, guys.
People
There's something definitely going on, and I don't think it has to do with my
stay because they want their children to have access to their father.
but it can also be the reason why they want to leave.
Another reason why they might leave is oftentimes, people will start with violence against their partner, but then that might also go down to the children.
It isn't stated whether Fravel displayed domestic violence towards the children, but they were exposed to the environment, and experts worry it could leave a lasting impact.
Either go on to 50% of the time become perpetrators themselves or become victims themselves.
Court documents say Fravel told Maddie if she didn't listen up, she would end up like Gabby Petito, another woman who went missing and was found dead. As Maddie's kids are in the custody of her parents, experts say it's important for them to have access to their emotions and to know who their trusted adults are. James?
Yeah, Jordan, absolutely. And we know from that criminal complaint as well that Maddie also looked to be in another relationship. She had met someone else. Before Fravel was charged with murder, he actually, though, had no criminal record. Isn't that right?
Yeah, James, that's right. According to the court records, Fravel has never even gotten as much as a speeding ticket. And despite charges coming down from the county attorney, she says more could be on the way, including potential domestic violence and first-degree murder charges. Whether those are added will depend on the result of the investigation, which is still ongoing.
That's good.
Jordan,
That's good. That's good news.
Tonight. Jordan, good work. Thank you. That criminal complaint also goes into detail about the path prosecutor.
This is interesting because let's be honest, we identify here on the Bullhorn Betty channel 3 ways to make yourself a really despicable person. And it can be singular, it can be combination, it can be all 3. And those are drugs, alcohol, and violence. Drugs, alcohol, and violence. It doesn't take all 3 to make a despicable person. It is no shock to me that Maddie was abused physically by this man. This would make sense as to why we're at the situation that we're at. People just don't typically go from being a nice guy to murdering their loved one and dumping them on the side of the road. It just doesn't happen that way. So you've got Adam here that is now charged with this crime. He was, when we went out there, now mind you, he brought up Gabby Petito. Well, I don't know, Adam, if you know, but I was one of the original protesters in front of Adam, Gabby Petito's house, Adam. And I was in front of your house as well. Just FYI. Just FYI. We don't like threats related to Gabby Petito. And it just shows you the kind of man this man was. Now, granted, he is presumed innocent until he goes to court. We are not a court. We do not have a jury. And in the court of Bullhorn Betty, he is guilty as sin. We went out there and, followed his path. I knew when I went out there, I gave you guys the lay of the land. I told you my thoughts and opinions. And guess what we also touched on? We also touched on the possibility of Maddie having already met and started seeing potentially someone else. I was very cautious in how I presented that. We presented that as a possibility, as opposed to a statement of fact. And there was reasons for that, but I also wanted to be very cautious and cognizant of the family and the potential of the family watching the show. So I was very careful about how we talked about that, but we put that as a possibility and a perspective to look at as we were driving to Fillmore. So we did have that. Let's just hear and see if anything else, if this person has anything really else to say. That was really the crux of what I wanted to show you.
Say Adam drove the day Maddie first went missing. Remember, it was this route along Highway 43 that remained the focus of search efforts right up until Maddie's body was eventually found.
And I want to
Fravel
also
told police
remind.
he took Maddie's van around 10 in the morning on March 31st, the day she disappeared.
Oh God, I hate these videos. So also we did, sorry guys, I was trying to stop it. And usually whenever I have my cursor over it, it usually just stops. Well, when they are on their websites as opposed to YouTube, it doesn't work that way. So I'm trying to get back.
But according to the complaint,
to the spot where the area, I think it's right here.
On March 31st, the day she disappeared. But according to the
don't even let me rewind. Like
drove.
There we go. That's where I want to pause.
Right up until Maddie's body was eventually.
That's where I want to pause because we were in all this area. We were off of 12. We went down 43, Highway 43. We were in this entire area when I went to Winona, Minnesota. So this was the area that we identified yesterday, possibly the area where they may have found Maddie Kingsbury, based on the information that we had received from the articles and law enforcement, because they were very specific. They said it was near his Mabel home, within 3 to 4 minutes drive off a gravel road, and disguised and hidden under brush. And when you see this area out here, you will see that, where are my projects? Projects. Everything on my, I don't like this whole thing with I won't do this thing again with the internet. I promise. I was just trying something new. I don't really like it. There we go. share this with you guys. It's just moving slow, and I think it's the way I set up the internet on here. So give it just a second. All right, let's go out. So there's the box kind of coming up into your screen. That's the box that I think that's the area that I truly believe that she was put in, because if you look, that's really the only gravel road near in close proximity, unless it's further up this way over here. But that's it. You can see that it's in close proximity to their property, and it's a wooded area that has like a gravel road off of Highway 43. And based upon their description that they provided to us, they won't give us the specific location that they were at, but they gave us enough detail that I believe this is the area that it has to be, because of there's no other area like this within a 3 to 4 minute drive from Adam's house. This is the area. So I'm curious to find out whether I'm right or whether I'm missing an area on here. This just conjecture. This is just literally from some articles that I've read. This is not a fact find. This is not factual information. This is an assumption made. This is an assumption made by me as to where Maddie Kingsbury was, put. I hate the idea of calling it dumped, but that's what this man did. He threw her away like trash. He dumped her like she didn't even matter. The mother of his children has the audacity to go and take her and have her drop those kids off at daycare, and then takes her home and murders her. I have a funny feeling this was premeditated. I have a funny feeling that's going to be the finder of fact in this situation. He's charged with second degree because that's what they can prove today. Their investigation, as we learn, is still ongoing. So just some interesting stuff that oh, shoot, I didn't mean to do that. Interesting stuff about Adam. Let me see if this is the one. I think this is the one we just did. Yeah, and here's another one that I wanted to show you guys as well. But again, I'm sticking on my end, so hopefully it'll work right.
When I served, my work was critical.
Yeah, it's like really sticky on my end. I don't know what the heck the problem is. I think it has to do with StreamYard. I almost want to end StreamYard just
whatever you're dealing
with,
call the Veterans Crisis Line.
I don't know what's going on here. It's just freezing.
Authorities found Madeline's body near Mabel yesterday.
Fillmore County investigators were searching an area north of Mabel off of Highway 43 when they found her body. Our Darian Letty has been in Mabel today checking out the scene and talking to local residents. And Darian, can you tell us exactly where and how her body was discovered?
Tom and Caitlin, I'm here off of Highway 43, just north of Mabel, kind of near the Choice Cemetery. Now, this is the gravel road where Maddie's body was discovered yesterday when Fillmore County deputies were out following a lead in her disappearance, and they found her body there, covered in some brush. Now, we actually went down there today when the scene was cleared, and I did notice some areas with tire tracks and some areas where grass was kind of matted to the ground. Looked like people were maybe walking around. Now, also yesterday, the father of Maddie's children, Adam Fravel, was arrested on probable cause in connection to Maddie's death. Now, I was in Mabel today and I spoke with some locals about Adam. I learned that he was a graduate in 2012 from Mabel Canton High School, and he participated in football and basketball. Some people said that they knew his parents and that they were nice, seemed like a normal family. And they also said that stuff like this just doesn't make sense happening in a small town like Mabel.
That's what the neighbor told me as well.
Worried, there's people out there that would do something like that and just think they're going to get away with it, but they're not going to. They get caught one eventually, but it's a shame. It's too bad.
Now, also today, I stopped by Adam Fravel's father's house, where he is believed to have been staying since Maddie disappeared. I knocked on the door and got no response. Now, their property is actually just a few miles south of where I'm at right now. But police want to stress that the property where Maddie's body was found is not owned by anybody in the Fravel family. Reporting near Mabel, Darian Letty, KTTC News.
So at least we have some more video of the area related to a visual of the area related to the gravel that we're looking for. So I'll still keep hunting along Highway 43 in Mabel to see if we can identify specifically the location she was at. I will try to do that today. But getting on to more information. Oh, this is, okay, we're done with that. We're done with the Google Earth. Okay. Like even closing out stuff is just a pain in the ass right now. It's going to be a rough live today. I don't know why. It's just giving me all kinds of problems today. So I'm going to apologize in advance. Hopefully you guys aren't seeing it on your end. I'm hoping you're not. But I have a funny feeling when I do the replay, I'm going to notice it like really, really bad. But hopefully not. We'll see. We'll see. Let's go ahead and pull this up. This is now we're going to kind of get back into the conversation of Brian Coburger. Brian Coburger's hearing yesterday. Many of us attended it. One thing that I don't like is we got the first part of the trial out. We didn't get the second. So we only have video of the hearing yesterday in its entirety for the first part. This is the Shannon Gray. I love this argument. And, you know, when we were talking about this and we were listening to the tweets, it was very apparent that this judge is ridiculously married to this non-dissemination order. And it's a little off-putting, to say the least. It's very off-putting that we have a judge acting in this manner this early on in this case and fighting tooth and nail to keep this in spite of the Supreme Court. In spite of the Supreme Court. Now, he has not made his ruling. I know he's clawing at his own non-dissemination order, trying to keep it in place as much as possible. And this judge has just got to come to Jesus and understand what he's doing is wrong. And I know sometimes you wanting to do something for the good thing, but I agree, Court TV did a terrible job. The audio sucked, everything sucked. What they disseminated to the public sucked. But it might have been at the judges. You know, the judge is not too interested in broadcasting this. You know, he applauds his local media. Of course he does. Of course he does. Because, you know, let's be honest, they suck the tit of the politicians in the area. That's what we saw when in Chatham County with the local media. That's why we were there, because the local media was sucking the tit of the garbage that the police chief was trying to lie to his public, right? He was lying to his public. Hey, we have no reason to arrest the lady. He never told his public Layla was on double probation and couldn't pass a P test, right? That's automatic violation of probation. You don't need a reason. You don't need to be convicted of a crime. You don't need contact with law enforcement to go back to jail when you can't pass a urinalysis when you were on double probation. You know, but he wasn't informing his residents of that. Oh, we just don't have enough right now. We need to make sure that we dot the I's and cross the T's. Bullshit.
Oh, come on now. That ain't even bullshit. That's horse shit.
Anybody that's been doing this long enough knows better. Knows better. Right? They know better. It's garbage. Crap that you do in Chatham County is garbage. This small town, Latah County, these judges aren't used to people telling them what to do. They're not used to this kind of attention in their small community. Well, guess what? Knock, knock, we're here. Okay? You need to move over and make room for us. Trying to block us out is not going to end well. I mean, let's be honest, it's not ending well. We've already got a Supreme Court published opinion basically stating, yeah, media has a right to be here. They have standing to be in here. And they also have standing to address First Amendment constitutional issues. Right? So here's some articles. Then we're going to go over the actual hearing, because I know a lot of people may have missed it, may have not missed it, may need to hear it again. I always find listening to certain things several times, you get to pick more stuff out of it each time you listen to it. So it's not going to fall on deaf ears. This is a huge hearing that has not yet been decided. I'm glad to hear the judge is going to take his time and research the law. He said he had a spot of food poisoning on the last hearing. I don't believe that either. I believe he's nervous. I believe he is ultra nervous. I believe he is terrified of presiding over this case. He doesn't seem very strong in its lack of experience in this type of case. And again, it's no diss to the judge. We're glad he doesn't have the experience in this type of case. You know, that tells you he's got a fairly safe community. So we like to know that judges don't have the experience. But again, when a case like this does pop up, guess what? We need a judge that has experience in handling these cases. And I just don't think in Latah County we have that going on with this judge. Personally speaking, I digress. But we'll see. You know, this may be on-the-job training in this type of case for the judge. Maybe he just needs to review the law. Maybe he needs to look at the statutes. He needs to look at prior case law. And you know what? He may come out with a favorable opinion that none of us expect because he did his due diligence. So I'm giving this judge the opportunity to do his due diligence, but I'm waiting for him, when he makes a mistake, them taking this to the Supreme Court. I think it's a horrible game to play with this Wendy Olson, but Wendy Olson seems like she's up for the challenge. It sounds like she's up for the task. It sounds like she's up to representing her clients to her best ability. And that means even taking on a Latah County judge. That's what she's going to do. Good. So in this case, it says the Idaho murder suspect's defense says the media will find a way to twist anything they learn, even if that means learning that Brian Coburger has a blue toothbrush. In all fairness, I can't dispute that, right? I know that there is several people on YouTube that will be, well, you know, he got the blue toothbrush, and I think it has something to do with his incelious, iciness, cold heart, murderous. It has something to do with the fact that he's a serial killer, and, you know, he could have had any other color. Why blue? Right? We know that this is not an exaggeration. Let's be honest, okay? Even if that means Brian Coburger uses a blue toothbrush, hands down, have to agree. Probably somebody out there in YouTube, on social media, will probably make the leap through some telepathic means that because he subconsciously picked the blue toothbrush, he's got to be guilty. Right? We know it's going to happen. We know it. Okay, so we can't dispute this. As funny as it sounds, we cannot dispute the blue toothbrush theory, okay? The blue toothbrush theory is real, folks, okay? The blue toothbrush theory is real. I'm not going to dispute it, okay? You don't come here for me to tell you what you want to hear. Come here for me to tell you what you need to hear, okay? The blue toothbrush theory is legit. I agree. But my position is we have the the right to explore the blue toothbrush. Okay? We're not saying the theory doesn't exist, that we're not going to pick apart every single bristle of this blue toothbrush. Okay? Well, we will look at the toothbrush. We will see if there's any plaque on it. We're going to make sure that it's utilized 3 times a day. We want to see a buildup of toothpaste around the base of the bristles. We want to make sure that this toothbrush is truly utilized by Brian Coburger. We want to make sure that it wasn't planted in his cell by some super cop that just wants him to be guilty, okay? This is going to be legit scientific discovery of this blue toothbrush and its effect on Brian Coburger's mouth. So I'm not disputing the toothbrush theory, okay? The blue toothbrush theory is real. But my thing is I don't give a rat's ass who you are. I don't care if you are the judge of this case. You are not going to tell me what can come out of this right here. You do not have that jurisdiction, Judge. That's one thing you do not have. That's one thing you do not have. Now, what he does not have in his court is the fact that he is weighing heavily on the 6th Amendment and not showing the First Amendment enough love. He needs to show the First Amendment, the cornerstone of our entire Constitution, some love. And this judge isn't getting it because he's got a prosecutor saying, shut this case down. He's got a defense saying, shut this case down. It's very hard when you have a defense and a prosecution actually working together and agreeing on something, which never happens, hardly. That's why we have judges. You got them both saying, hey, we want this. The judge is saying, okay, we got an agreement. No problem. The parties have agreed on something. They have stipulated on something. But the problem is that we have rights too. And that's where this court has made their fatal mistake, is the fact that, yes, we agree that there are parties to this case. We agree that those parties do have rights to a fair trial. We have a great understanding of that. We also have a great understanding of the 14th Amendment, which, Judge, I don't think you are utilizing that 14th Amendment very well, because it's prescribing you to handle these things fairly in the same way each and every time. You have no problem having cameras in your courtroom any other time, just not with this high-profile case. That I have a problem with. Why are you fighting so bad to keep the public out of this trial? Maybe it has nothing to do with disturbances. Maybe they don't want us to see them making mistakes because they know they're under the gun with Shannon Gray. Like, the Gonzalez family already has an attorney. And you can see how disrespectful that state attorney has been to that family. And let me tell you something, Bill Thompson. You better hope you prosecute this case very well. Because the disrespect you showed that family and continue to show that family is disgusting from where I sit. It's disgusting. And as much as I want you to win the case, I hate knowing that you, after being that disrespectful to a victim's family, I don't want you to have that win under your belt. I don't. Putting him up on a pedestal after treating the family so horribly? I can't wait until the Gonzalez sues the shit out of this county and the city for what they did to them and continue to do to them to this day, to use the law to shut them up. Let's be honest what's really going on here and what this is really about. They lied to the public and said that this whole non-dissemination order was because the prosecutor was leaking information. Well, what I heard yesterday had nothing to do with the prosecutor leaking information or the need to have a non-dissemination order because of the prosecution or the defense talking to the media. It was for everybody else. The people they don't have the jurisdiction on. I think this judge is overstepping his authority from what I saw yesterday. I mean, he hasn't really overstepped his authority yet, right? His authority won't be overstepped until that order comes down. but I still believe he's overstepped his authority. I think anybody that has any legal mind, any minor legal education can see that this is an overstep of authority. It's overly broad, it's vague. They seem not to have a problem with it. I do. I have a problem with that kind of conduct. So we do agree with the blue toothbrush theory, okay? The blue toothbrush theory is a real legit issue, okay? We would analyze the crap out of a blue toothbrush, let's be honest. if it's all we got. Now, you guys know, because you guys have been following me, how I feel about this nonsense, right? Like, if it's a public trial, it should be open to the public. Who gives a rat's ass how you get your public trial? Whether you get it by phone, get it by internet, get it by radio, get it by newspaper, or watch it online. Who gives a crap? It is a public trial consumed by the public, for the public. Who cares how they get how they consume it? That's my point. I don't give a rat's patootie about anything. That's how I feel about it. It will continuously be how I feel about it. The defense team representing the man accused of murdering 4 University of Idaho students last year told Latah County judge on Friday, it doesn't matter what the public or the media learns of their client, they will find a way to twist it, even hypothetically, if they learn he uses a blue toothbrush. But see, this is what they're failing to provide the judge. It's within our rights to do so. That's the problem I'm having. Even with that statement, I'm agreeing 100% with that. But how dare you think you have a right to tell me I don't have a right to discuss the flippin' blue toothbrush? Are you flippin' kidding me? You're trying to tell me that every little twitch, turn, stuff, I have no right to discuss according to this judge. But hey, you're not hindering my First Amendment rights in any way. Okay. Now, I don't know if you know this or not, but I love the law. Love it, love it, love it. I love the Constitution. Why? Because it limits our government. It tells our government what they are allowed and not allowed to do. It doesn't tell us what we're allowed to do. It tells us what they're allowed to do. If I run a stoplight, they're allowed to issue me a ticket. If I get into a bar fight, they are allowed to arrest me for battery. If I get into an automobile accident while under the influence of alcohol, they have the authority under the law to arrest me for driving under the influence of alcohol, for breaking the law in place. So our law is the guidance of our government, our police, and our officials that run our country. And right now, the judge in Latah County is not following the law. It's not the media not following the law. The media has a right to talk. They have a right to dissect a blue toothbrush if they so choose. They have that right. That's the picture we're missing. That's the picture we're missing. And I agree. I agree that misrepresentation, I don't want to go to a channel that misrepresents facts, right? I don't want to be led down the wrong path. I want factual information. But you know what? All of this misinformation that they're referring to is because of their very non-dissemination order. They're creating the vacuum that's causing all of this nonsense. The courts, the defense, and the state are the ones that are causing this circus. Brian Coburger, 28, is charged with fatally stabbing Xander Kernodle, Madison Mogan, Kaylee Gonzalez, and Ethan Chapin in their home in Moscow, November 13th, 2022. And he's expected to go to trial on October 2nd. You guys know I don't believe the trial is going to go forward on October 2nd. So we're going to go back and we're going to listen to this from the beginning for all those people. If you guys want to take a break, get your coffee. If you've already seen it, I'm putting it on for the audience that has not had an opportunity to watch this hearing in its entirety. Guys, this is only one section of this. And I'm going to skip ahead a few minutes to provide, there were some audio issues that happened up front that I try to, get you guys past so you're not having to watch or look at it. But again, I do hope the audio and visual is coming in properly on your end. It's not doing it so well on mine. But we will play this. This is going to be about an hour. You're more than welcome to watch. You're more than welcome to comment. Tell me your theories. We may stop it. I'm not sure how I'm going to do it yet. We'll just see how it goes, how the flow goes once we get started here.
Is participating, observing on Zoom.
Okay, let's go back.
Family is the state represented by Mr. Fox.
Okay, here's the beginning.
And Mr. Rudley. Mr. Coburger is in the courtroom, represented by Ms. Taylor and Mr. Watson.
I don't know if you guys can hear it. Turn your volumes up. It's awful. The audio is awful.
Let me sit back here, Your Honor. And I believe some of the family is participating, observing.
Thank you, Sutter Grammy Wolf. 8 months.
So before we get into the arguments, I want to address the Gonzalez family and all the families, really. Didn't really have an opportunity to do this at the arraignment. My heart does go out.
Oh, thank you, Steffers. Yeah, I don't know what's going on with my internet today. I checked it.
The loss to your children is devastating and horrific. I mean, there's no dispute about that. I also want to acknowledge and apologize because at the arraignment, I did stumble over a couple of the names, Kaylee's name and Zayman's name. And I want to explain that. I was up all night, really ill.
I call bullshit on this. Hold on. Let me get it.
Warning, bullshit alert.
I'm calling BS on this because I truly believe this judge, it was nerves. It's funny because think about it, right? Everybody always talks about food poisoning when they're going toward a major meeting. Look at Dr. Lewis. Remember Dr. Lewis from Letitia Stout?
Oh, yeah, I wasn't feeling well. I think I had food poisoning. That's why I was late this morning. I couldn't make it in after you warned me 15 times to be here on time. I just couldn't because I had food poisoning.
Such a lame excuse. It means you had nerves and you probably had diarrhea because of those nerves. Okay, Judge, tell us what you really mean. Okay? I should stop. Sorry for all those people that are having digesting problems and don't want to think about poop this early in the morning. I did it. I think it was nerves. I just don't. I don't think it was food poisoning. Sorry, Judge. Not believing it.
Probably food poisoning, and I was not at full potential. Probably also some emotion and nerves.
Yes, emotion and nerves. Let's be honest. You had those cheeks flapping, right? Those cheeks are flapping. You weren't feeling too good, Judge. You mistaken Kayla for Kaylee. Kaylee for Kayla.
I read those names, and I'm sorry. So that's my apology for that. I know some people were bullshit. I also wanted to explain a procedure at the arraignment that apparently drawn from the media that some people were confused.
Oh, and I do want to say this. I do want to say this. Shannon Gray, clever attorney. Clever. That man was able to wield insults at the judge under the guise of freedom of speech. You're going to get to see that. It's later in this, but it's so hilarious. It is so hilarious when you see there, because he's talking about, you know, if I were to say you're crazy, judge. I wonder where he was, that on the top of his head? I'm just wondering. Very clever attorney. Very clever.
When Mr. Coburger declined to enter a plea. And I just wanted to clear that up because I didn't really see any explanation about that in the media. That is Mr. Coburger's right. And under Rule 11A1 of the Idaho Criminal Rules, this is a quote, if a defendant refuses to plead, the court must direct the entry of a plea of not guilty. That is not unusual. But reading the media, it seemed like somewhat mysterious. So I wanted to explain that, particularly to the media. It's a small issue, but it's somewhat, well, I think that I have an obligation, just as the media has an obligation, to help to educate the public about the processes that we are responsible to follow.
So the judge is directing. I want to put this into perspective, and I think this is going to be brought up later, especially if this goes to an appellate type of situation, is the fact that he feels that he has the right to dictate what people say. And I think that that's going to be the crux of their argument, is that we have freedom of press. That means you're not to be hindered in your reporting. Yet this judge is on the record stating that he wants to restrict and basically tell them what they are allowed to write about and say and produce. And that is a big problem for me. It's a big problem for me. I don't know if this judge is making that connection or not, but the people out here, at least me, I mean, I think I have a fairly good understanding. I don't know all the intricacies. That's why we have case law and we do legal research and stuff like that. But I don't know all the intricacies of a lot of the stuff, but I have a good understanding of the law in general, the United States law, as well as state law, as well as how the states are broke up and what laws they govern. There's different sets of laws, whether it's community property or common law. I mean, you've got a lot of different things that you have to look at when you're looking into these, but I still have a good understanding of the law. And no matter what kind of law you're talking about, from my understanding, you can't tell the press what they have to write about and how they have to write it. To me, that seems in clear violation of the freedom of press, in my opinion. And I think the argument is there. And I think this judge is doing himself a disservice. I really do. Just my opinion. I think he's doing himself a disservice.
In the courtroom, and that's important for journalists. That's also important for the citizens. So, if you're curious about that, you can always find the criminal rules on the Idaho Supreme Court website.
Okay, so now it's not even, you know, he wants the press to go out there and teach and educate their audience on the criminal justice law. Sure, happy to do that. We got something coming up right now after this. It's Nebraska Press Association versus Stewart, right? What you constantly keep hearing them say, right? We're going to listen to that argument. We're going to educate our audience. We're going to educate you. Stay here. Since the judge is telling me what I have to be able to, what I can and can't do on my channel, what I can and cannot say on my channel, he wants us to educate the public. Sure, Happy to, Judge. I don't think you're going to like my education because I hone in on the First Amendment, freedom of speech, the cornerstone, the bedrock of every single law we have on this in this country. You know, I hone on that quite a bit. You know, we'll go over what you need us to go over, Judge. Happy to do so. We're here, right? This is the Bullhorn Betty channel. We want these animals off our streets. We want safe roads. We want good environments. That's what the Bullhorn Betty channel advocates for. Happy to educate our audience, much like we have, about how this is a horrendous non-dissemination order. We are educating our audience on the law. Believe me, Judge. Believe me, I'm educating my audience on the law. I definitely am.
Very, very easy to read them and maybe get a better understanding. All right, so that's my speech for today. Mr. Gray, come on up. And
if you allow me just a minute or two to get sorted out here.
Take your time.
Thank you.
Thank you, Mr. Gray.
And before we go too far, I want to just show you guys. Remember yesterday, before we even heard the hearing, what did I tell you we had? What did I tell you we were going to be going over? Remember that? Why do I have all this insight about what we need to be doing next? It's called common sense. Okay? It's not like I have the secret back door to these people in this trial. It's called common sense. And we already had it on yesterday. I said, you'll never believe what I dusted off, right? What did I dust off? We're going to go through this. We're going to teach you about criminal law and procedure. This is a book I got from college. I dusted it up. Had to blow some of the cobwebs and dust off of it. We got it. We got it. One of many books, by the way, one of many books. You know, we have all this kind of stuff, this technical writing. We got our citations book, our legal citations book. You know, we've got all of our tools that we need. We got all of our tools, stuff that I've had for many years. So let's just keep going. Good morning, Ann.
Can I proceed, Your Honor?
Yes.
First, Your Honor, we'd like to thank you for apologizing to the victim's family. I think it was an emotional day for them, and they appreciate your apology. I know that they took that part up. Thank you. I first want to start with the procedural history of this non-dissemination order, if I could. On January 3rd, 2023, the Judge Marshall submitted a non-dissemination order. And in that order, it applied to parties in the action, which would have been the prosecution, the defense, and any agents, investigators involved in it. After that non-dissemination order was issued, I reached out to the prosecutor's office to see if I could get Judge Marshall's email. For some reason, I don't know if they took it down, but I couldn't find it online. And they informed me that they were not privy to give me that information. Then on January 13th, there was a Zoom call that was requested by Judge Marshall. That Zoom call was requested at 1 o'clock on the 13th. I received an email at 12:58 from Judge Marshall's clerk requesting a Zoom call to speak to all interested parties. The Zoom call occurred at 4 o'clock. During that meeting, the judge reminded us, all the parties involved, it was the prosecution, it was the defense, it was myself, it was the attorneys for the victims' families, the attorneys for the witnesses, I believe were there as well, a number of attorneys, and reminded us that her non-dissemination order mirrored that of Idaho Rules of Professional Conduct 3.6. As part of that hearing, and I think it's details here, she talks about the rule applies to all lawyers participating in the Zoom meeting, the state and the defense, and all attorneys for the witnesses. When she had that Zoom meeting, and I've requested the transcript from that Zoom meeting and haven't been able to receive it yet from Judge Marshall's court, so we could have a full transcript of what went on that day. But as part of that meeting, I had questioned Judge Marshall regarding the victim's family and whether or not they were allowed to speak to the media based on the fact that she had said all interested parties as well in the initial non-dissemination order. I didn't receive any clarification. I was just instructed to go back to Idaho Rules of Professional Conduct 3.6, as well as I was told, and it's
3.6, that's the rule. I kept saying 6.2, but that's part of the other rules related to some of the work that they're doing in the criminal case and some of the stuff that they're arguing about as they're standing for this non-dissemination is the 6 point something, but it's the 3 point something that that is a little questionable, but still, I think he's reiterating the saying that they've got ethics, they've got ethical obligations that they're required to maintain as being an attorney to even possess and hold. Sweetie Pie, thanks for being the newest member of the Coffee Club, this crazy place we call the Coffee Club. Thank you guys, thank you. And so, you know, they have this. Anyways, let me hold on 1 second. I lost my train of thought. Like literally while I was talking about it, it just went like that. Let me just back up here. I know what he was saying, and I'll remember it. Just a second. Back up to
go back to Idaho Rules of Professional Conduct.
Oh, now I remember. So, you know, the rules, they're trying to incorporate this ethical guidelines and ethical rules that are already part of them having their license and maintaining it. So that means the Idaho bar, like we have the Florida bar, the Idaho bar requires them to maintain certain requirements, including ethical training and adhering to strict guidelines to be an attorney in the state of Idaho. They've already got rules and regulations that govern their license. They don't need to have an order referring them to what's governing their license. Every attorney already knows. Like, you don't want to be in front of the Quality Judicial Commission. You know, you don't want to be in front of them. It's a scare. Even if you're innocent, you don't want to deal with them. Nobody does. So this doesn't. The regulations are already in place. They don't need to be, what is the word I'm looking for? It starts with the I, redundant. We don't need redundant stuff. The redundancy is ridiculous in this case.
3.6, as well as I was told, and this is in quotes from her Zoom release, take their duties in utmost regard in conducting themselves and advising their clients. I took that as I should tell my clients to be quiet. She reiterated that again in the Zoom call by saying that I had ethical duties ascribed above in the Idaho Rules of Professional Conduct for commentary of Rule 3.6. And she reminded me later that lawyers have a responsibility in giving advice to their clients. I disagreed with Judge Marshall on almost every point during that meeting. As well as if I had known that we were going to be discussing the Idaho Rules of Professional Conduct in that issue, I would have prepared. But only having a 3-hour notice didn't allow me, and not knowing what the subject of the meeting was going to be, didn't allow me to address those issues at that time. Now, after the non-dissemination order in January 3rd, and then the January 13th, 2023 meeting, the judge amended the non-dissemination order on January 18th. And she basically repeated the same order, except for she added the attorneys for any interested party in this case. including attorneys representing witnesses, victims, or victims' families,
Thank you,
as well as
Jennifer.
parties to the above entitled action. So you can see the difference is that the first one dealt with parties to the case. The second one went way over the top, addressing all attorneys that might be associated with the case or any attorneys that might have an interest.
Way over the top. Way over the top. I think that is the gist of the legal community related to this. I really do. I mean, this is, I have to be honest with you. I have been out of attorneys' offices in courts for many years now. I mean, at least close to a decade, maybe less than a decade, because I was married for a decade and I was still working for a law firm when I was first married. So, I mean, it probably about at least 5 or 6 years. I've been out of the biz for at least 5, 6 years, maybe 7, might be 8. I can't even remember. I can't remember when my last day, right? I can't remember. But either way, and granted, we're not, you can be in law your entire life and not run into some of the issues that we see here, you know, covering true crime. You can work in the business your entire life and not have a lot of these issues be ever be presented for you. So just like the judge is, in my opinion, doesn't have the experience in this type of case, it's hard for anybody to have a total experience in these types of cases in totality. It's just very difficult because there's so many nuances. There's so many different arguments. There's so many different defenses that it makes it, you know, all they really have is a standard procedure to follow, right? So it's just, it gets into these tricky topics that it's hard for us to prepare for. This is one of the situations, and just like the judge, I am ignorant and in some respects, and I also don't have the experience in a lot of this stuff. I mean, we're gaining experience every time we watch these trials, every time we see how they're processing the evidence. You know, when we're growing up and we're watching, say, like the first 48 or forensic files or things like that, we're only seeing those aspects of the case. We're not seeing how those work in conjunction with a trial. We don't have that where it gives you the full circle from the investigation from the first 48 hours to the actual processing of evidence, the forensic files, to the court, i.e. like court TV, how those all play. The only time we get that in good context is to watch these trials and see how those are built. But we still don't understand it unless we're watching from the beginning and know exactly what was collected, know exactly what was processed, and know exactly from what was collected and processed to what is being admitted in trial. There is a disconnect there in the education of, you know, media, in education of news reporting. You know, I can agree with the judge that, hey, some of these processes need to be explained to the audience, need to be, and we're going to do that. And we were planning on doing that before he ordered the press to do that. A judge ordering the press of what to write, speak, and talk about. This is not the America I grew up in. Sorry, just not.
Party in this case. So that's where we are today. I filed a motion based on that additional language.
Happy birthday to your niece,
I'd like to get into some of the issues here. It's very clear that I am not a party to the case and the victims' families are not a party to the case. That's very clear through all of the case law, as well as.
Can I interrupt you?
Yes.
There's no dispute about that.
Okay. Then
You're not. Your clients are not parties. The only parties of this case are the state and Mr. Coburger. That's
okay.
And that's clear. That's clear in the case law with regard to any victims or victims' families. There are constitutional protections and statutory protections for victims and their families.
I would agree.
That's well established.
And, you know, it's also well established that just because there's protections in place doesn't prevent you from waiving said protections. And maybe that's what this judge and this court's trying to do, is force the Gonzalez to waive some of their protections, right? I mean, it does sound like the Gonzalez family is planning on suing the crap out of this city, out of the police department. They've already, provided notice. They're getting the shaft from the judicial system. They're getting the shaft. And they're being disrespected. And that's the part that is the most frustrating for me, is how they are being treated. They lost their daughter. Let me put this in perspective. They lost their daughter. They are so lucky that they have this Gonzalez family. And they're complaining about the Gonzalez family. They are. From the very beginning, about how tenacious they were, how they went out and got, the Gonzalez family, in all reality, kind of put the police department to shame, because the police department blocked them out and they were able to still acquire evidence in their daughter's case. They put a team to work. They have a big, beautiful, loving family, and they sat down and they became a family. They've been a family, but they became a family. It was a small corporation behind the scenes called the Gonzalez family that was seeking answers for Kaylee and Maddie. They had lost their children and they wanted to know why. And law enforcement was blocking them out. And just like any good family would do, just like me, I see an obstacle, I go under it, over it, or around it. And that's what the Gonzalez family did. And they are lucky that they're dealing with a loving family like the Gonzalez, because you get the hot mess of Bullhorn Betty. I don't know if I would have been as courteous or as nice to these people as the Gonzalez family has. I think they've been, in face of all of this, they have been courteous and nice. I don't know, honestly, and this is, I'm being absolutely 100% honest here. If this situation was flipped and my little sister was one of those victims, are you kidding me? And you're telling me to sit down and shut up? It would never happen. It would never fly. It would never fly. I'd probably be getting the biggest, baddest attorney I could find as well. But I guarantee I would not be near as respectful as the Gonzalez family. I think they've been utmost respectful. Touch a hair on my sister's head. Respectable Bullhorn Betty just went out the window. Sorry. It ain't happening. It ain't happening. I love families that can hold it together. All right. I know myself. I know how well aware of myself I am. And that I've been faced with this and somebody tells me to sit down and shut up. You've got to be kidding me. You have got to be kidding me. Like, I would look right at that and say, you don't ever talk to me like that again. Let's get one thing straight. I remember at the last law firm I was at, I remember one of the attorneys was asking questions. I popped up and said something, and I can't remember it. He was having a really bad day, and he snipped at me at a round table. As soon as that meeting was over, I went into his office, slammed his freaking door, and told him, you do not ever talk to me like that in front of people again. If you've got something wrong, you have an issue, you have a grievance, you pull me to the side and we'll talk about it like adults. But you ever put me in a position like that again, me and you are going to have serious problems, and I will not hold my tongue next time. Like, I held my tongue until that meeting was over. But no, trust me, what you see is what you get. Okay. I didn't just wake up one day and become like this. This is who I am. I'm one of those people that you want respect, you give me respect. You have all the respect in the world when I first meet you. You have all the trust in the world when I first meet you. I give you that freely. You take that away from yourself. Your actions, your conduct, how you treat me takes away from that. And that's no different inside these, in these, when I was working for attorneys. I'm part of the team. I have a great understanding of this stuff. I do my job very, very well, and I will not be disrespected in front of the office. Will not happen. Long story short, needless to say, I had a bottle of booze sitting on my desk the next morning with an apology card, right? And that situation never happened again. And people wonder why I address situations the way I do, because I'm one of those people that think that if you address something up front and you're assertive about it, You don't act like people know what you're thinking. That's another big problem I think the world has. They assume that you're just automatically supposed to know what chip on the shoulder they have today. No, be vocal about it. If you have a problem, be assertive. You hurt my feelings because I'm in a foul mood because. Don't walk out the door, slam the door, and say nothing's wrong. Clearly something's wrong. The only person you're lying to is yourself and everybody around you. And you know how I feel about liars. Something's bothering me. Just say it, right? This judge is bothering me, right? I don't like how he's thinking.
So let's get into the actual non-dissemination order itself, how it addresses to me personally as the attorney for the victim's family. This non-dissemination order, of all of the cases and all of the motions that were filed, and referencing every case that was listed in this case, none of them apply to a victim's attorney, an attorney representing the victims. The Idaho v. Tap case was an attorney speaking about a judge who he was in front of. The Good case was a defense attorney.
This is where he gets clever. This is kind of where I really like Shannon Gray. And I know behind the scenes, there was some chuckling going on. I'm just saying, because when I heard this, I know over here behind the scenes, whether you guys could see me or not, I was chuckling a little bit. I have to be honest with you, because I kind of agree with attorney Shannon Gray.
Attorney that spoke to the media. The Mezabov case was a defense attorney and a prosecutor. The Morrison case was a defense attorney and a press conference. Varner versus Delahunty was an attorney and a judge, all parties to the case. Cutler was a defense attorney, U.S. v. Cutler. Zhao versus Slack was a defense attorney. Irwin versus Dowd were the prosecutor's actions and speaking to the media. Shepard v. Marshall, Maxwell is a trial.
Here, let me really piss the judge off, right? Let's really get under the judge's skin today. Like, I'm looking at Brian Coburger's body language, and he just does not look pleased. He looks like he's guilty to me. Oh, I'm sorry, Judge. Are you going to hold me in contempt of court? I'm just curious.
Publicity regarding the prosecutor's actions prior to trial. None of those things apply to the victim's family or the victim's attorney in any way. Now, I do agree that the court has the power to control those that are parties to the case and that are involved in the case in some way.
The light's around here somewhere lurking.
But we have to define that. What means involvement in the case? Part of that is that the judge referred to the Idaho Rules of Professional Conduct 3.6, trial publicity. She references that multiple times as the basis for her non-dissemination order in this case and how it might apply to me. If you'll read the first paragraph, a lawyer who participates.
I want you guys to hear this. We're going to back up just a little bit because he said something important. Let me go back 15 seconds.
Idaho Rules of Professional Conduct 3.6, trial publicity. She references that multiple times as the basis for her non-dissemination order in this case and how it might apply to me.
So they're saying that it's pre-trial publicity and how it's going to be applying to this this witness's attorney. Now, mind you, they're stating that he's not a witness to the crime. The family's not a witness to the crime, not a witness to anything, but may, not shall, but may be called as a witness in the sentencing phase. That means after the conclusion of the stinking trial, by the way.
If you'll read the first paragraph, a lawyer who participates or has participated in the investigation or litigation of a matter shall not make extrajudicial statements. That is not.
He's clenching his jaw, folks. He's clenching his jaw. He must have been guilty. He has to have done it. He clenched his jaw. And he's using a Bluetooth brush.
Not me. It never has been me. It can't be me because I'm not involved in the litigation. She also says that.
Can I ask you a question about that? Because I think the case law is quite clear that attorneys who are representing witnesses.
See, this is where they're trying to open a back door to a witness of a sentencing. The Gonzalez family is not classified as a witness to the facts of this case, which is what they're trying to prevent from getting out into the public. So if they don't have any testimony related to the facts of the case, how can they be deemed to have information that can't be publicly stated? Doesn't make sense. None of this entire proceeding to a normal person, to my normal brain, makes sense.
Can be restricted to some degree, partly because they have access to particular information that may not.
What access, Judge? Particular information what? Because they went out and collected the information. Let's put this into perspective. They're trying to bar. Now, mind you, they have no evidence, no witness, no nothing that the state has provided them. They have gone under oath. They've even stated here under oath to this judge through their attorney that they have never had any information, never been questioned by the state attorney, but somehow the state attorney is still labeling them as a witness, and they've never even had a meeting with the state attorney. Not even a meeting. Not an interview, not a deposition, nothing. This is a prosecution that is not holding his law license too well when you're going to manipulate and purposefully, with malice, lie to a judge about a witness's family or about a victim's family. That to me is disgusting. And if this shows me how Bill Thompson or Thomas Thompson is going to be running this case, I'm very concerned. I'm very concerned as to whether Brian Coburger will truly receive a fair trial. And what other tricks, nasty little side tricks, is Bill Thompson holding up his sleeve? This is a trick. This was dubious. I almost want to say fraud upon the court. Let's see how they can stretch this garbage.
Should not be shared with the public. And if I'm recalling correctly, the state has suggested or has determined that your clients are witnesses potentially. So that's kind of the
And I can
issue
address
right
it, Your
there.
Honor.
Go ahead.
As part of that is that, let's just make it clear, the victim's family has never been involved in this investigation, ever, from the get-go. After Mr. Coburger was indicted, we received no information about anything regarding the prosecution, nothing. They wouldn't even tell us that a grand jury was being impaneled for Mr. Coburger. They told us that there was a grand jury that was being impaneled, and common sense, we figured it out, because he's the only guy in the county. But they wouldn't even relay that information. They haven't given us any information regarding the investigation of the case. But the most critical part of it is that the prosecution has never, ever interviewed the Gonzalez family. So how in the world would we ever be able to be witnesses in this case? And for what purpose would we be? If you're asking about for sentencing purposes, that's post-conviction. That's after he's been convicted on the case. Prior to trial, we're not any witnesses. And that falls into completely different statutes. That falls into the restitution statute. It falls into the victim statute. I just handled that matter in front of the Lori Vallow case, where the judge, I had a motion, the defense did not want the victim's family to appear. And so the judge had to make a determination whether they were immediate family, because it was the grandparents. Completely different statutes, because that was post-conviction. And those witnesses were allowed in the courtroom and were involved in the sentencing aspect of it. Okay? So we are in a very, very different factual situation here. I'm not asking as a witness to the case, they've never ever told us in any way how we would be witnesses in this case, other than the conjecture that we may have potentially. That's not good enough to stop the free speech of the victim's family as well as myself. The other thing is that
you're saying it's possible. You're indefinitely restricting somebody's First Amendment freedoms of press, freedoms of speech in a case on a possibility. And this attorney is absolutely right. That is not good enough. It is not good enough. You cannot do this. This judge should be, at this stage in this judge's career, he should know these things. I am a flippin' paralegal from Florida. This is criminal law 101 in my opinion. And I think that these lawyers just get on these kicks where they go into all these different rabbit holes and try to find and try to look. It's common sense. This judge is being ridiculous in this matter. Absolutely ridiculous in this matter. He's so scared to make a mistake. He's making mistakes all over the place.
if the victims can say whatever they want, they're under free speech and that's exempt, why would I not be allowed?
So the victims can say whatever they want, according to this judge, but their representation cannot. That seems like, what is the purpose of having counsel represent you if your counsel can't even speak? And this judge is literally entertaining this nonsense, right? What Supreme Court will allow a retained attorney not to speak on behalf of their client? You tell me what Supreme Court in this country is going to side with this judge on this one matter alone. You tell me. I'm interested. Find me a judge that would say that this is okay. A Supreme Court judge, not a magistrate judge, not this ridiculous guy sitting behind the podium here. A Supreme Court judge that has handled plenty of cases. This is showing this whole thing. You know, I was so hopeful when we found out about Brian. I was so hopeful when we found out that we were getting a new judge on this case, and Megan Marshall, a magistrate judge that just doesn't have the experience, was stepping down, and I was very pleased with that. Now we get this Yahoo judge that is basically a spitting image of Megan Marshall. You know, it doesn't look like he knows whether to scratch his watch or wind his butt. And I'm sorry, this is becoming a very unprofessional trial, and it's magnifying the ignorance of this court and the prosecution. You expect this from the defense. That's their job. But from the judge and the state, this is for a person like me and normal people that understand these things. Like, I don't expect my audience to understand the law. I mean, that's why they hire attorneys. But for the law professionals that are out there on social media, Twitter, Instagram, YouTube, and otherwise, why are they not talking about this? An attorney is hired and can't even represent his stinking clients. What Supreme Court is that okay in? It's not.
Allowed to say the same thing that they say.
My understanding is that your clients are not restricted in any way, never have been.
Well, and I'll give you an example.
I mean, is that true?
That's right. Well, I agree now, because that's not the tone of the Zoom meeting.
Well, we're not talking about the
Okay.
tone. I'm talking about the language of the order.
Yes, the language of the order now, because any interested parties, I ask for clarification, now understand that they can say whatever they want. And that's correct. But here's the problem. If they said, we think the judge is crazy, would I advise them against that? Absolutely.
Thank you.
But if I went and said, my victim, the family asked, has said that they think the judge is crazy, there's nothing wrong with that. I'm repeating exactly what they said. Now, what comes into play is, for our purposes today, is what if I offer up my own opinion, right? Well, then I'm already governed by the Idaho rules of professional conduct. And if
I'm glad you're acknowledging that.
no, well, every attorney is, Your Honor. I mean, it's not, every attorney is. So the idea that I'm not, but every rule doesn't apply all the time. If I'm talking poorly about a judge, another rule might pop in. 8.3, I think is what it is, or 8.1. If I'm saying other things that might affect things another way, then maybe the probability. But The trial publicity, I don't even think applies to me in this anyway, because if you look at it, it says it applies to a lawyer who is participating or has participated in the investigation or litigation of a matter shall not make extrajudicial statements. And it goes on, highlighted by Judge Marshall, then in paragraph 3. The rule sets forth a basic general prohibition about lawyers making statements that the lawyer knows or should know will have a substantial likelihood of materially prejudicing the adjudicated proceeding. And at the bottom of the paragraph, it says this: rule only applies to lawyers who are or who have been involved in the investigation or litigation of cases and their associates. If I'm not a party to the case, I can't be involved in the investigation or the litigation of this case in any way. So I would argue that the trial publicity rule of professional conduct does not apply to me as well.
Help me understand what you think you can't say that you've already been saying.
I have no idea. I have no idea what.
And again, how is somebody going to possibly be able to explain to a judge every little thing that could possibly come up? It's not. And if this judge is using that same standard, what are you not allowed to say? Well, if the non-dissemination order is not working, Judge, maybe it should just go away, because this is a lot of judicial resources being utilized to keep an unconstitutional non-dissemination order in play here. Now, I would have to warn our audience, as well as people that may be watching this video later, that this is a vacuum that was created by this non-dissemination order. They're complaining of the repercussions of this non-dissemination order and the misinformation being peddled out there in through media and social media, but they're the ones that created this this misinformation campaign, because they are refusing to allow anybody to even glean information such as, how is the community healing? They even went as far as to put into their pleadings, one of their memorandums or their objections or their statements, that, you know, they're not even asking, are they sure they got the right guy? My thing is we're not even allowed to ask that under this current non-dissemination order, because all they do is cite the gag order as the reason for them not being able to respond to that question. So again, this is being created by this non-dissemination order. They're angry that their non-dissemination order has created this horrible issue with misinformation being peddled by Dateline. Now, mind you, that came after the non-dissemination order. Every single one of these documents that I have reviewed, let's pull it up. I got it all right here, right? All these documents that we have reviewed in connection, oh, this is not the package. That's the package. This is the first package. Hold on. I got the wrong package. I got the wrong 500 documents that I need. Let me grab the other 500 page documents that I need. So in here, let's look at this. So we got the state's brief on photographic coverage. That's not what they're talking about. We're in the non-dissemination area of this particular matter. So let's look at that. So here's the motion to take judicial notice, which they accepted in the case. I heard that. We don't have the video of the second case yet. Maybe by the time we're done, they will have uploaded it. But let's go ahead and talk about this. Let's read these dates. So here they have all this stuff listed, right? All this stuff listed. This is their example of the misinformation and why they need the non-dissemination order in place. Now, mind you, this non-dissemination order has been in place since January 3rd, the day that Brian went to his hearing or waived extradition and was on his way back to Idaho. Megan Marshall put in a non-dissemination order. Actually, she filed it, but guess whose name was on that non-dissemination order? Oops, that way. That man right there, John C. Judge. Judge was the person that signed that initial order back January 3rd, 2023. But now we've got their evidence. They want him to take judicial notice as to why this non-dissemination order needs to still stay in place. not a non-dissemination order for the first time, mind you. This is one that they want to stay in place, that has been in place since a reform of it since January 3rd, 2023. Now let's listen. Let's look at these dates of who they're complaining about and what they are complaining about, that they need this non-dissemination order still in place, right? Because it's already in place now. This overly broad, unduly burdensome, not narrowly drawn non-dissemination order is currently in place and has been in place since January 3rd, 2023, the beginning of the year. Now they've listed here, although Mr. Coburger notes that this court may simply take judicial notice on its own of any press coverage it's aware of under IRE 201C1, he specifically requests the courts to consider the attached articles. Let's look at these. So Caitlin Hornick, capital punishment. Family of Brian Coburger's victims will seek the death penalty for Idaho murder suspects and speak out on plea deal. This was issued on the Sun. What was the date? May 29th, 2023, some 4 months after the onset of the non-dissemination order. Madeline Kogan, perils of evil. Ted Bundy survivors speak out, linking their gruesome attack to Brian Coburger. This was listed on foxnews.com on what date? Oh, May 28th, 2023, some 4 months after this non-dissemination order was put in place. C, Stephanie Pagones, accused Idaho killer Brian Coburger's body language compared to Lee Harvey Oswald. New York Post. What date? May 23rd, 2023, some 4 months after the onset of the non-dissemination order. Sherry Mossberg et al. Here's why Idaho student's murder suspect Brian Coburger may have chosen to stand silent in court. May 23rd, 2023, some 4 months after the non-dissemination order was put in place. Fatman Khalid, Idaho murder victim's father, has a warning for Brian Coburger. That was in Newsweek, May 12th, 2023, some 4 months after the non-dissemination order was put in place. Melissa Koenig, if they are in over their heads, then acknowledge that. More than 6 weeks after Idaho murder, Kaylee Gonzalez, family lawyer question if police are capable. This was the only one thus far. There's 2 of them out of this laundry list thus far that had been prior to the non-dissemination order. And it says if they are over their heads, then acknowledge more than 6 weeks after the murder. They have a right to bring that up. That was a question we all had. And they were discussing that. Again, this is First Amendment. They cannot dictate to the press what they can write about. And that was a legit question that deserved some conversation. John Webb, Gonzalez family attorney, speaks out on 1 month anniversary of murders. That was on December 13th, 2022. Again, nothing that was diminishing, nothing that would have prevented Brian Coburger from receiving a fair trial. None of that. You according to this court, they don't even want you breathing Brian Coburger's name unless we're talking about kitties and puppy dogs and anything but murder. We can talk about Brian Coburger, according to this judge here. We can talk about Brian Coburger anytime we want to, just as long as we don't discuss the case. I'm sorry, Judge, you do not have that authority over me. You do not have that jurisdiction over me, and you do not have that jurisdiction over the majority of the news conglomerates out there. And while you may like your local news and may want to give them a boost in views and clicks and money, at the end of the day, you are beholden to all of us, not just your local news organization. Capital punishment. Let's look at some of the articles that they've posted in this. May 29th, 2023. 4 months after the non-dissemination order. Exhibit B. The perils of evil. Ted Bundy speaks out. Again, 4 months. So they added all their stuff. Here's the article that was prior to the non-dissemination order. Let's see if there's any information in here. Any possible information in here that can affect Brian receiving a fair trial. Okay. And again, prior to the, this was on the 29th and the 12th. This was prior to Brian Coburger even being arrested. Therefore, this entire court had no jurisdiction on anybody prior to January 3rd, 2023. None. This judge had no jurisdiction to tell these people what they could have wrote about in December. But somehow, because they wrote in December, which they had every authority to write, is somehow being held against them now. Let's read what this says. A lawyer representing the family of slain University of Idaho students Kaylee Gonzalez is publicly questioning whether local cops are capable of solving the quadruple homicide. Speaking to the Today Show in an interview Monday, Shannon Gray told how the Gonzalez family is extremely frustrated with law enforcement's lack of answers more than 1 month after their daughter's death. Okay, how is that going to prevent Brian Coburger from having a fair trial? Kaylee Gonzalez, 21, was found stabbed to death inside her off-campus house on November 13th, along with her roommate Madison Mogan, Xana Kernodle, and Ethan Chapin. No suspects have been arrested yet. Therefore, there's no jurisdiction to limit their press, yet they're using this against them, right? But still, nothing that's going to prevent Brian Coburger. His name wasn't even mentioned. His name was not even mentioned in the stinking article because nobody knew about him at the time. So how is this preventing him from having a fair trial? I digress. No suspects have been arrested yet. As Moscow police continue to comb through evidence that Gonzalez have hired their own private investigators to get some answers and urge local businesses to turn over any surveillance footage that may help. How is that preventing Brian Coburger from receiving a fair trial? We want to let them know we're holding them accountable for their decisions, Gray says. How does that prevent Brian Coburger from having a fair trial? If they are in over their heads, then acknowledge that and turn the investigation over to someone who is more versed in handling these types of matters. Again, how is that preventing Brian Coburger from having a fair trial? I'm not sure they're capable of handling a quadruple murder, he said. He's allowed to have his opinions, and so is the Gonzalez family. How is that preventing Brian Coburger from having a fair trial? Keep going. Gonzalez family has been very vocal about their frustration with the Moscow Police Department over the past few weeks. They're allowed to. It's not the first time that parents get frustrated with the investigators of a case. Actually, very common. Very common. They had met with Moscow Police Department just last week. They previously told Today's Show, but they still felt that they were being left in the dark. How is that preventing Brian Coburger from having a fair trial? The parents said at the time they had entered the police station with 5 pages of questions about the investigation, but left with not much. How is that preventing Brian Coburger from having a fair trial? Christy Gonzalez, Kaylee's mother, now says she cannot sleep at night as she continues to wonder what happened to her daughter. It's sleepless nights. I'm feeling sick to my stomach, she says. It's so many emotions I've never, ever endured in my life, ever. She added that she fears the case will never be solved. I mean, I'm honestly, that is a possibility, she admitted. There's a lot of unsolved murders. How is that preventing Brian Coburger from having a fair trial? But ahead of the holiday season, Moscow Police Department Chief James Fry said investigators won't stop looking for clues. Oh, so he's allowed to have an opinion. He's allowed to speak to the press, just not the Gonzalez family. Got it. So not really about the fairness of Brian Coburger's trial. It's really more about shutting the Gonzalez family up because the Moscow Police Department is somehow offended, or the state attorney, Bill Thompson, is somehow offended. So let's just flag them as potential witnesses in the sentencing phase, and we're going to get them to shut up. See how this works? Doesn't seem above board, does it? Starts making you wonder why they're blocking the public out of these very public trials. because we actually have brain cells that can actually argue these things and want answers on them. How is this article preventing Brian Coburger from having a fair trial? Judge, I'd like you to explain that to me. Prosecution, defense, explain it. I'm open. I'm open. So far, everything I've read here has been true and factual and opinion-based, and those opinions are well written and well taken. So I don't understand how this is preventing Brian Coburger from having a fair trial. Somebody explain it to me. I must be stupid. I must be stupid. They're now sifting through a database of 22,000 registered white Elantras that fit the description of one found at the scene the night of the murder. Police have said in the past that the driver may have seen something that could be relevant to the fatal stabbing. I don't know how that is going to prevent Brian Coburger from having a fair trial. There are now multiple groups scanning through clips as they are trying to track down those responsible, Fry said, as he vows his force will continue to work over Christmas. In the meantime, though, Gray is urging the public to continue to submit tips and share information with authorities. Sounds like exactly what the chief was asking of everybody at this time. Again, how is this preventing Brian Coburger from having a fair trial? Now, this was the reason why I'm only honing on to these articles, because this was before the non-dissemination order and does not seem like it seemed like this was a very good, well-rounded article before the non-dissemination order was put in place. And I think this, if the judge actually reads this, I think he will see this himself, that yes, it seemed like they had better coverage of this case without the non-dissemination order. As soon as that non-dissemination order went in place, guess what? The mainstream media started bringing in anonymous sources and things of that nature. And you're going to get a lot more of that if this non-dissemination order stays in place. Therefore, your non-dissemination order is doing exactly what you're wanting the non-dissemination order to stop. It doesn't make sense. The interview comes just hours after Kaylee's father denied that the man his daughter was seeing, talking about just hours before the death, is a suspect. He was telling him this guy is not a suspect. I remember these conversations. Newly released security footage shows Kaylee was walking along the street with Mogan, her best friend. Nothing in this article has been pointing the finger or been defaming or provides any kind of misrepresented or poor reporting. None of this. This was before the non-dissemination order. Much better reporting, much better specific factual information than we've seen in the May articles. You know, after the non-dissemination order, should be your first clue, Judge. Judge. If you take the earwax out of your ears, maybe, possibly. So here's the second one that they were talking about from the Daily Mail. I think that was the one on the Daily Mail. Hold on, let me look at their what they all had here. They have the exhibits. Let me go back to this. I don't see one from the Daily Mail. Oh yeah, there it is. It's the last one. So F. Let's read what this one said. Let's see if this one can prevent Brian Coburger from having a fair trial. And again, this is another article that was written prior to the non-dissemination order. The video was first uploaded on Facebook group, the University of Idaho Murders Case Discussion. The pair were at the Corner Club until 1:30 a.m., went to the food truck, and then got a ride home. Police have already said the driver of the car is not a suspect. Not sure how that is going to prevent Brian from having a fair trial, but this is information that was provided to the public through public records that was factual and information. And it sounds so far that the people writing these articles prior to this non-dissemination order were writing really good articles. One of the administration of Facebook group, Chris Campbell, Fox News, we can all scrutinize those couple of minutes of the food truck, but we just have to remember there was an entire evening before this. Sounds like great reporting. Not sure how this is going to affect or how it can affect Brian from having a fair trial. There's more than just one timestamp that we have in that evening. Speaking of a man who was previously seen with the pair at the food truck, who is also in the new video, Cameron said people are drawing the conclusion that he's creepy, and that in that few minutes, I won't give a bigger picture. He wasn't just staring at them. He was just with them prior. Sounds like pretty good reporting to me so far. It was also reported over the weekend that the Gonzalez was afraid of a stalker in the weeks leading up to the murders. Really? Stalker? Interesting. Brian Coburger just happened to be a stalker at their property. Imagine that. Factual information. Apparently, Latah County courts don't like the public having factual information. It was reported over the weekend that Gonzalez was afraid of a stalker in the weeks leading up to the murder, something Moscow police have denied knowledge of. Oh, that's right. They can misrepresent to the public, but good God, don't let the media or the press do it, right? Don't let the media or the press do it. But let the chief of police, carte blanche, go ahead, misinform away. Misinform away. You're allowed to do it, but nobody else is. Got it. Sorry. A vape shop smoker claimed he discussed Gonzalez stalker with her and Mogan 3 weeks before they were slain in their bed. He told News Nation Kaylee and Maddie were both came in here. They always had a smile on their face. They were a light of the world. They always came in with a group of 4 or 5 girls at most. All the time they would come together. All the times they came together. I made a joke to them coming together that it was nice to see that they were staying safe. Maddie then said something, oh, a friend of ours is being stalked. So that's how the whole stalking thing came up. Again, I don't know how this is going to prevent Brian Coburger from having a fair trial. This was information that was released by the law enforcement at the time through press conferences and press releases. Let's not forget that. All this stuff that they're listing in this article was provided to us by law enforcement. Every bit of it. How is this preventing Brian Coburger from getting a fair trial? So you see the gist of the reports of the articles before the non-dissemination non-dissemination order went into place, and you see how radical and crazy the reporting got after the non-dissemination order went into place, leaving me with the conclusion, if you actually look at the evidence and information, judge, you will see that the non-dissemination order is the cause of all this problem. Remove the freaking order or modify it under the law properly. That's all I'm saying. So there you got it. I'm educating my audience with the facts of this case and how ludicrous these arguments are for this non-dissemination order, and to classify the Gonzalez under a weak, they could possibly be called as a witness in the sentencing phase. Yeah, let's see how well that flies in the Supreme Court, buddy. Okay, they're going to shut your butt down. They're going to shut your butt down. So I've got this other case going on, and we may have to do this later this afternoon. I'm not sure. I'm still trying to figure out what my day is going to look like. But I thought this was important, and I wanted to show you on my rampage of complaining about this non-dissemination order and how ridiculous it is, and how it's doing exactly what the judge is saying he doesn't want happen. I mean, it's the document causing the problem, dude. If you haven't figured that out, I don't know if you're the right judge for this case. I'm just saying. The proof is in the pudding. We just read the proof. Much better reporting prior to the non-dissemination order. Period. Hands down. Much better reporting. Much more factual information, much more concise information, and it didn't prevent Brian Coburger from having a fair trial. Imagine that. Imagine that. So they go through all this. Some people have the threads in here. These kinds of videos, often created by people with no training, have become hugely popular in the true crime world, and we've already seen plenty of them in the Coburger case. And I think the problem is what people are failing to realize. It doesn't matter. It doesn't matter what they write. They have a right to write whatever they want to. I think that's the bigger point people are missing. I like factual information. I don't want to read, conspiracy theories. But I'm a First Amendment person. And I know that even the conspiracy theories are covered under the First Amendment to the Constitution. Period. So I do agree that, we've talked about it here on this channel, especially TikTok. TikTok's a bad, some of the stuff that we get on TikTok's really good, really interesting, really factual. But there's a lot of conspiracy theories out there. There's a lot of people, like I watched it myself when Brian Enton was, and I think at Mar-a-Lago, I actually talked about Brian Enton about this very topic. And he told me that, what was it? It was some type of, let me think about this. I remember being out there and we were talking about something that he had posted. And now I forgot what it was. And I will think of it in just a second. But he posted something. I can't remember. I'll circle back to it. But either way, the bottom line is even lies are protected under the First Amendment to the Constitution. I'm a constitutionalist. You're not going to change me from my stance on the true meaning of the Constitution. I've studied it. I love it. I've got books and books over the heritage of the Constitution. It's just, it's a piece of my DNA. The Constitution, the law is a piece of my DNA. I love it. It's what keeps this country running. It's what keeps, our politicians and our government in check. Trust me, if it wasn't for that Constitution, we would be slaves to our government. All of us. Our government doesn't care about us. We're all a number in the grand scheme of things, right? What's your number? Go look at your Social Security number, right? That's your number to this government. That's all that you are, is a number. They don't see your face. They don't care who you are. They don't care how you're living. They don't care whether you're happy, sad, miserable. They don't care. It's the only document that keeps our government and our country in check. And when you're telling me that I can't say something, you got the wrong one. Because I have built this channel. I have built my reputation on this right here. Long before I ever got to YouTube, this right here is what was used out here in these streets, these real streets. But I do agree. We do have to hone in on this. There are, at the end of the day, we have the freedom of speech. Even these people that do this for fun, that like to do, rabbit holes, that like to do conspiracy theories, they have a right to do that. That's their choice. That's their life. The government can't control that. They can't control how we think. They can't control how we process information. They can't control what we choose to read and what we don't choose to read. And this is what this judge is trying to do. It's not going to bode well in the Supreme Court. It's just not. I hope this judge smartens up, but it seems like he wants to fall on his face. Let him fall on his face. You got to hit a wall a few times. Hit the wall a few times. I personally choose to be wise instead of smart, right? I'd rather learn from other people's mistakes instead of my own. I'm just saying. How about the nice sheath they found? Sounds to me like it was staged. I absolutely believe that was left there intentionally. Nobody's talking about that. And I've addressed that. I even put a question up on Jennifer Coffendorfer because nobody's talking about, they're talking about it as if it was unintentionally left there. I have not heard one person talk about the perspective of it intentionally being left there and what the repercussions of it intentionally being left there and why would it intentionally be left there. This is what the judge is saying that we're not allowed to talk about. Excuse me, judge, you don't control my voice. You don't have jurisdiction over me. You're not going to tell me what I can and cannot write about or say. And if you don't want me to misinform my audience, I would suggest you make it a way for me to get factual, updated information that can be relayed to my audience in a constructive and positive manner. Just saying. We hear a lot about this Nebraska press versus Stewart. This has come up quite a bit You heard them arguing it with Attorney Gray. Well, maybe you haven't. I don't even think we got that far yet. Let's go back here. And we got the hearing. And we've got the arguments right here. And we're going to go over them because we're going to educate our audience in the law. You damn right we're going to do that. We're going to do that because I want to make sure that next time something like this happens, you guys know it's wrong. Just because he's a judge doesn't make him right.
You've been on the media and you've had interviews. So I'm kind of wondering how do you feel that you've been restrained in any way with this order?
I think you're not seeing what the point is. What the point is that
I understand
the court has issued a non-dissemination order that restricts First Amendment rights, that is overly broad in almost every aspect of it. Anybody that's interested and they have an attorney. When an attorney who's walking down the street could offer up his opinion in any way, it also takes away from the idea, doesn't the court want victims' families to have representation, to guide them through the legal process? Wouldn't the court encourage that they could explain things, say, maybe advise them on what to say, what not to say? I mean, if you're taking my voice away, you're taking the voice away of everything. The other part of it is this, is that I'm absolutely blown away that the prosecution doesn't agree with me in this case. The reason being is that they are representing the victims, which in turn are the victims' families. And I have not seen a poorer line of communication in my 22 years of practicing than the prosecution's office and the Gonzalez family. And I think it stems from, initially we were critical of the investigation. They wanted to find the person who did this. That's normal emotions. And then from that point on, it has been, we are the enemy. And that's how we feel in this. And so me guiding them and then trying to limit my voice and helping them out in some way, and then throwing out a random idea that they may be potential witnesses when they've never ever interviewed them in any way. It's just an attempt to shut the attorney up and shut the family up, is what it is. Because if I had come to you today and said, we've given 7 interviews, Your Honor, we may be witnesses in this case, we've done all of these things, it may be a different story. We haven't done anything. They haven't interviewed the entire family. So,
well, I don't know what's in all the investigation, obviously, and
maybe he's worried Steve may jeopardize the case in heat of the moment. But that's, you know what? That's the whole purpose of them having an attorney, so that doesn't happen. This court is preventing that attorney from speaking on their behalf to prevent that very thing right there, the heat of the moment aspect. So again, the courts are creating this issue and then pissed off that this issue is created. They're doing it to themselves. And I don't know how to express it or explain it any clearer than this court is doing all this to themselves. They're creating this vacuum. They're creating this circus, and they're preventing us from getting factual information that we can use to stop with the misinformation. We're not asking for information that's going to jeopardize the stinking case. Not every tidbit of information in this case has some aspect that will prevent Brian Coburger from having a fair trial. That's why it is so overly broad to have a blanket non-dissemination order, and why it's so wrong in these courts to have a blanket non-dissemination order, which will not pass legal muster in the Supreme Court. It will not. This judge is going to have, if he keeps this going, he's going to have a very difficult time explaining his position to this court, to the Supreme Court. He's going to explain it in his way, the way we're hearing it here, but it's going to fall on deaf ears when you actually have judges that know how to interpret the law. This judge is taking his direction from a defense attorney and a state prosecutor and not using his noggin to properly, properly handle these debates of this case. He's listening to this. He's acting like he doesn't have a brain for himself.
A lot of us don't know and probably won't know until the trial.
And the other
Okay, and, well, let me just say this. I think one of the potential issues is this is potentially a death penalty case. Hasn't been noticed, but that is a potential. And the families of the victims certainly would be witnesses in that process of sentencing. Now, that is not post-conviction technically, is it?
If your goal is fair and impartial jury, right? That's the reason for the non-dissemination order. Well, after the conviction, that goes away.
Well,
there you
it's
go.
Also confidence in the process. So
Nobody's got confidence in this process. I can tell you that.
Protecting and preserving the First Amendment,
which you're not doing.
Also, the Sixth Amendment,
which you're heavily.
There is some balancing there. That is why.
Which you're not doing.
Lawyers who have access to information that is not accessible by the public have particular restrictions. That's what this whole case is about. In this hearing is about.
And as an officer of the court, I can tell you we have zero access.
Okay, so you're
saying he's saying as an officer of the court. This is what, when you heard him say, I'm an officer of the court, what he's telling this judge is that I'm an officer of this court. I'm bound by ethics and I have to be truthful in my dealings with you, sir. And I'm telling you, as an officer of the court, we've had no interaction. So he's basically saying to the judge, I'm testifying, telling you that my clients have had no interaction with this case and have no inside information about this case other than what they've garnered on their own. And that judge cannot prevent them from talking about stuff that they garnered on their own, only what the investigators and the parties to the case have and the information they have. If I went out tomorrow and researched this and found another person, a person of interest, or the person that did this crime, not Brian Coburger, you cannot prevent me from going forward and saying, hey, I found the real killer. You can't stop me from doing that. I found that on my own. I'm allowed to bring that to light. Now, once I bring that to light, you might be able to go to court and say, hey, she's got some inside information and this is prejudicial. We need to silence her. And then maybe they could have enough meat on the bone to silence me at that point. But the action has to be, they can't just assume that I'm going to do this and restrict me because I might do it. They can't hinder my First Amendment rights over their assumption. And that's what it is. This is an assumption, and they're hindering all these people's rights over an assumption of something that has never even happened yet. Explain that to the Supreme Court judge. These non-dissemination orders are crucial in criminal investigations. When you've got a Yahoo judge that is overzealous with their non-dissemination order, it causes problems. And it causes problems for the rest of the judges that know how to properly preside over these types of cases. Unprofessional.
That the prosecutor's office has not shared information with your client.
Regarding the facts of this case, no, they haven't.
Right.
How things occurred.
Everybody's going to have a chance to weigh in on this, and I just, you're helping me understand what the issues are. So thank you.
Well, so that's really the issue here. I mean, and this is an important ruling because what you're doing is this has never happened before. Ever has it happened before that a Judge Marshall, has tried to silence the attorneys for victims. Never has it happened.
And that is the truth. And that is where this argument is the most the strongest of Shannon Gray's arguments is that statement right there. I have never in the history of me working ever had a judge prevent the victims from speaking. They have no authority to do so. This judge may think he has authority, which is crazy to me, but I mean, he does have some wide authority over the parties of the matter, but you have to be a party of the matter. They're trying to retroactively state that there's a possibility that they may call him. Look, the Gonzalez can say, why don't you sign a thing and say, I'm not going to be a witness at the sentencing. Here's my statement for sentencing. Go ahead and write them an affidavit of what the statements will be at sentencing, and let's get that out of the way so he can't be a witness at sentencing. There's a way to do this. The way they're doing it is wrong. And what this state attorney is doing is just disgusting and despicable. That's all I'm going to say. It's disgusting and it's despicable what this state attorney is doing to the Gonzalez family. Shame on him. Shame on him. He is lying to the court. That is what Bill Thompson is doing. He is lying to the court.
Would you feel more comfortable if there was a
Don't
more
worry, Bill. He knows soon he
concrete
come to Florida.
description of what people could say and what they can't say?
I don't think you have the authority to, Your Honor.
Well, I think I do have the authority.
Well, my argument is that part of the argument is that.
In fact, I know I have.
That is the most pompous thing that attorney has ever, or that judge has ever said. This judge needs to come to Jesus. He needs to be pulled back off his pedestal, and he needs to follow the law as the law is written in the state of Idaho and quit making up hocus pocus rulings and law that suits him because he thinks he's the judge and ruler over the Constitution. No, sir, you're not. And the Supreme Court is going to put you in your place. You keep going down this road. Believe that.
Well, and the authority would be through your the attempt to have a fair and impartial jury, that you can control people.
And that's it. This is where I have the biggest problem, is this judge is saying he wants a fair, this is not about a fair and impartial jury. This is something bigger than that. Because this man keeps arguing about, they're wanting to shut up the Gonzalez. It is very well positioned in this hearing here that this is a hit to shut up the Gonzalez family. And here's why. Because the judge is trying to make this stretch that they're going to possibly be a witness at this sentencing phase. Again, after the verdict, after the jury has concluded their job, they may be a witness. Again, if this is about a fair and impartial jury, that is a moot point. What is done after the verdict is a moot point because the jury was fair and impartial in getting that verdict. So you're talking about things that don't even make a difference if that's truly your objective is the fair and impartial jury. Why are you arguing about what they can say if they're not even going to be part of the trial, the actual physical trial, while the jury is present, while the jury can take testimony and later deliberate if it's about an impartial jury? It's not about an impartial jury. This is painting a very clear picture that this is to silence, that the state attorney is willfully and maliciously trying to silence the Gonzalez family. And if this judge doesn't pull his head out of his butt, they're going to have a massive lawsuit that he's most likely going to be a part of because of the crap that the state prosecutor is doing. And this state prosecutor should be held liable for his conduct. Lying to a judge, in my opinion, that is exactly what he did when he tried to classify the Gonzalez as witnesses. He maliciously and willfully misrepresented information to a judge.
People that are involved in the case, correct?
That's part of it.
And we're not involved in the case.
Okay, that's hard to accept. But
we're not witnesses in the case. We're not involved in the investigation. We're not involved in the litigation. I can't file any motions. I can't subpoena anybody. I can't cross-examine witnesses. I can't do anything. So this idea that there's this loose idea that there may be, weighing that versus our freedom to speak, First Amendment, is.
We're talking about your speech.
That's right.
Not your client's speech.
But that is my speech. That is part of it, though.
Well, in your memorandum, you are suggesting that you also have an independent position that you are representing yourself.
Yeah, I hate to break this to you, Judge, but when he takes his attorney clothes off, he's allowed to put his personal clothes on, and he's allowed to think, talk, and walk for himself. And guess what? That's also protected under the First Amendment, Judge. I know, shocking. I know it's shocking for somebody like you to comprehend at this point in your career, but I digress.
I do. It's distinctive from your responsibility to your clients.
That's why the motion is for amending or clarification, because there's the clients that have the free to speak. There's me repeating what they have to say. If they said the judge, we thought the judge was crazy, and I said the judge was crazy, I can't be, it doesn't violate the non-dissemination order because I'm allowed to say that. And then there's my independent voice where I said, the judge is crazy? Yeah, I think the judge is crazy. That goes into another layer, right? Where it would be, I would be, Idaho rules of professional conduct would fall into play, and what I would be doing or what I couldn't do.
Exactly.
Not the non-dissemination order, because we're not parties to the case. I'd be governed by the Idaho rules of professional conduct if I made those statements, extradite those statements. And I may or may not fall under the probability. I would argue that I don't, because I'm not a party to it. I'm not litigated it, I don't have any information on it, none of those things. So really, that's where the authority for me, for my voice, would come from.
So he's basically giving him the elements test. He's saying, here's the elements test. I'm not a party. I'm not this. I'm not that. There's no way that this law can govern me. This non-dissemination order can govern me because it's not meeting the necessary threshold in order to govern me. What governs me is the rules that I'm required to follow as being an attorney set forth by statute, not this non-dissemination order.
From the Idaho rules of professional conduct, if I did that. And if I made a statement that I thought didn't apply for trial publicity purposes, that would be an argument for another day. But it wouldn't be for you, for a contempt of court for me, because I'm not a party to the case and I'm not involved in the case in any way. I'm just repeating what my clients say, or I'm just saying my own individual opinion, which doesn't, by the way, makes it absolutely unduly prejudicial. Because what if a guy is on an Idaho bar member, is walking down the street, looks up, sees a television program where the Gonzalez family says, well, we thought the judge was crazy, right? And then all of a sudden, the media is outside, they interview him, they say, hey, you're an attorney here. What about the judge being crazy? Well, I've been in front of him 3 or 4 times, and I would agree with him. You're going to sanction him and contempt of court? You can't. Same as me, because I'm not a party to it. He's not a party to it. He might be governed by the Idaho rules of professional conduct by commenting on you, Your Honor, but it wouldn't be because of the judge's non-dissemination order. So how can it not apply to him, but it can apply to me? It can't.
Well, the case law suggests that because you represent potential witnesses, that you have access to information that may not or should not be shared with the public. That's what the case law says.
And I would argue this, what potential witnesses are we, number one, and what access to information do we have? I think the defense has argued that we have some sort of access because the clients can tell me whatever they want to tell me, right? Well, that's free speech. They can say whatever they want to me, and I can go off and say whatever I want that they said. Because it's free speech. It's the First Amendment. So you can't, I mean, this non-dissemination order is so broad, none of the case law applies to people that are outside of the defense or the prosecution. That's the point of it. That's the whole point of a non-dissemination order, because they have access to it. They have access to the information. Victims, attorneys, families do not. And the idea that we may or may not be a potential witness is enough for Your Honor. I just can't see that, especially when there's no history of them ever being a witness. And to tell you the truth, The day after they filed that notice, or the day before they filed the notice that we may be potential witnesses, we had just gotten out of a meeting with the prosecutor's office, discussing whatever we could discuss, like our concerns, because that's all we do is go in and talk about our concerns, and they tell us we can't say anything, we can't say anything, we can't say anything. We'll get to it. When we walked up, nowhere in that meeting were we described as being witnesses in this case. But all of a sudden, the next day, they thought we might be, even though they've never interviewed us. So they're throwing stuff in the air that is not justified, and the idea that he thinks maybe might is not enough to regulate my free speech in this as the attorney for the victim's family, because that's what we are. We're not attorney for witnesses, we're attorney for the victim's family. And if the court has any other questions, I'd be more than happy.
I understand your position.
Sure.
Thank you, Mr. Gray. So let me go to the state. I don't know if that's Mr. Thompson or Mr. Revel.
It'll be me. Can I have one moment, Your Honor?
Certainly. Thank you.
If I may,
yes, you may.
Mr. Rudley is actually going to be arguing on the motions themselves, but as attorneys, we have a duty of candor to the court. Mr. Gray has made representations to the court that at best are misleading and in many ways simply untrue. And I need to correct them for the record. Because the media is here. I do not want the public to come away with the impression that improprieties have occurred. First, Mr. Gray, on behalf of his clients, has propounded a number of questions to our office as investigators. We have answered the ones that we can. We have not shared ones that we are concerned that Mr. Gray or his clients would make public and compromise the integrity of the investigation. For him to say that we provided more information is simply not true. Secondly, he claims that law enforcement has not interviewed his clients, and that somehow that is the investigator's fault. In fact, from the very beginning, the investigators have attempted to interview his clients, and Mr. Gray has not permitted it. So just for the record, I want to make sure that's clear. Thank you, Your Honor.
If I could speak to that, Your Honor.
You'll be able to
Thank
come
you.
back in after you hear the other
Thank
arguments. Mr. Revel, go ahead.
Thank you, Your Honor. In State v. Spencer, the Idaho Supreme Court noted that it is also the duty of the prosecutor to ensure the right to a fair and impartial trial. Under the dictates of Shepard v. Maxwell, the court has a duty to take affirmative steps to address the impacts that intense pretrial publicity can have on a case.
All right. So I want to be very, very, very clear. The only thing that dictates law is the law. Okay? There is right and wrong. Now, I can't help that there's people out there that are idiots that have no understanding of the law. If you want your rights violated, by all means, go to Latah County. You know, go get a criminal charge in Latah County. It has nothing to do with other than educating my audience, which this judge has asked everybody to do. So I am taking his challenge. I'm going to educate the heck out of my audience about the law. And haters, you might want to stay tuned. It might help you in the future. We know you guys like breaking the law because you guys try to say you don't know that you broke the law. But unfortunately, that's not a defense in the United States. I didn't know that I broke a law, so therefore I'm not responsible. Right? So you guys want to have unfair, I have a very good understanding of trials. I have, you know, right? Everybody keeps saying I don't know what I'm talking about, right? But I've, been arrested, 43 times according to the haters, which is a lie. They know it's a lie. They still continue to peddle that lie, right? So, but I've only been charged with 2 things, convicted of 2 things, one from 20 years ago and one from 11 or 12 years ago. Ooh, big deal, right? So we just had a credit card issue, right? Everybody was on here. It was my ex-husband's credit card. Had nothing to do with me whatsoever, but obviously know the law there, right? Dropped, moved on, right? Right? Everything when it comes to this has been spot on. In all the cases that we have covered, even with some of the intricate laws and stuff like that, we may not get the specificity specifically right, but we definitely always get the spirit of the law correct. And that has been proven for the last 2 years. Like, you can't dispute that. So this idea that I don't know what I'm talking about, that I don't know right from wrong when it comes to the law, is absolutely incorrect. We are absolutely speaking about the facts, you know. And it's funny when I hear haters come into the channel and say, you don't say facts, you don't say facts. But then when I tell facts, they're like, oh, you're just upset because they won't let you grift. Really? Why don't you just acknowledge that you have no business being here on the Bullhorn Betty channel? Nothing I ever will do will ever be right in your eyes. That coming in here and disrupting my channel is doing absolutely nothing for your cause. Actually hindering a business. Lots of stuff. Lots of stuff. It's okay. It's okay.
As noted in Shepherd, Nebraska Press Association versus Stewart and their progeny, an order like the one in this case is an appropriate measure for addressing that duty of the court. As Mr. Boston's experts have noted, attorneys often have information about a case that may not be appropriate for dissemination in the press. Additionally, attorneys carry a greater weight when appearing on television.
Yes, they do carry a greater weight. I don't think anybody's disputing that. Now that this guy is, he was like an attorney that I used to work for, right? So as you see, this is what you're seeing this man do. Oh, let me take the camera off. It's when it's running, I think it's the bandwidth of the recording behind the scenes and all this other stuff. But anyways, so this guy is literally reading from his binder, okay? You're seeing him, you're hearing him. He's like, you can hear he's reading from it. He's not formulating his own arguments and stuff like that. He's literally reading from this book. Those are the books that I used to put together for my attorneys, right? Where we put their legal arguments in. We wrote the whole book. All we had to do was follow the book. Like, you don't even have to think. Just follow the book. Follow the book. That's what we always told the attorneys. Don't try to go wing it. Follow the book. Follow the book. And I'm seeing this guy and I'm like, oh, he's got his, this is his paralegal's arguments. This is not his arguments. This is somebody's arguments, but they're not his. They're not his, because you can tell just by the way he's arguing this, this is not his arguments. He's just the one saying them.
For instance, what might be easier for the parties to address is a juror that says, I've seen coverage on the case, but I don't always trust what I've seen on TV, and I can set that aside. What's more difficult is a juror that says, I've seen attorneys for the prosecution, attorneys for the defense, or attorneys for the victims on television talking about a critical aspect of the case.
I just want to put this in perspective. I really do. Can you imagine the repercussions of being able to prevent victims' families from speaking? It wasn't until he was talking just now. I don't know why it didn't click for me yesterday. But just the thought of knowing that a state attorney and a judge actually wants to prevent victims' families from speaking. I think this is probably the most unprecedented aspect of this nation order. And I didn't think of it in that lens, but now that I'm thinking about it, to prevent the victims' families When have I heard a law that has done that before? Or a judge that has ruled that way before? And I can't recall. Now, granted, I'm only 43 years old. Some of these laws were way before my time. Hell, some of these laws that they're relying on were way before this judge's time. So, you know what I mean? That seems like the most unprecedented, that a judge is literally trying to prevent a victim's family from saying boo. That's concerning to me. And the fact that this judge, this particular judge is entertaining these arguments is even more concerning to me. And the fact that I just heard Bill Thompson go up there and lie to a judge, but he didn't really lie. He lied, but he didn't. Oh, well, they could possibly be called for, the sentencing aspect. That is a lie. I have never in my life, good morning, Hellcat. I have never in my life heard that somebody can't speak because they may be called in the sentencing phase of a case. I mean, call me crazy. I've just never heard it. What? Why is Dolly's canceling it? Why is he canceling it? Why is he canceling it? Where did you find that out, Ruby? Come on here. What? Hold on. Hold on. Sorry, I went ahead and I had to cancel my reservations. I didn't want to be charged, right? I think we're going to Summer's Day, right? And I didn't want to tell anybody I was going because I didn't want to bring it. This internet is driving me crazy. Give me just a second, guys. I better be doing better here, and it's not. I don't know what's going on. It might be doing something. It might be okay on your end, but it's far from being okay on my end. And it seems like my internet is running just fine. It's something with StreamYard. It's the bandwidth with StreamYard. I don't know what it is. It's just, I don't know if it's the processor of this MacBook Pro just can't handle it. It's driving me nuts. That's all I can tell you. That's all I can tell you. And it might be the settings. I have a funny feeling it's the settings. I'm going to quit messing with the settings. There we go. All right, we're going to get back to this.
The matter of Gentile versus State Bar of Nevada, that case involved an attorney who held one press conference in 1991 after the indictment of his client. In this case, Mr. Graves repeatedly issued statements and been on television. At minimum, it's insincere to argue that he's feeling bound by the order when it's clearly not abided by. In Gentile, the court noted that the speech of attorneys is subject to less substantial, or it can be regulated by less substantial means. In this case, as we've shown by the affidavit we filed, the Gonsalves families are potential witnesses in a trial, or more specifically at sentencing. The order in this case is not vague, overbroad, unduly restrictive, or not narrowly drawn. It precludes all extrajudicial statements of the attorneys in this case, attorneys for the witnesses.
You guys hear him? He's reading. Like, he's reading his argument. That's what I'm talking about. You'll hear a seasoned attorney up there talking, and you'll hear an unseasoned attorney up there talking. I'm sure this is a very bright, younger attorney, but and he's probably very thorough. But his presentation is not going to be well taken by a jury. He's too tight. He's just. I don't know what to say, but he's like, he's as tight as a spring,
Victims, law enforcement, and investigators. The order addresses, if the court were to apply strict scrutiny, the order addresses a substantial likelihood that pretrial publicity poses to the integrity of the judicial system, and is tailored to ensure that the rights to a fair trial are upheld. As we briefed in the case of Levine, the alternatives such as sequestration of the jury or changing a venue aren't going to mitigate the impacts of statements, extrajudicial statements in this case, and are unlikely to do so. Thus, the state contends that the order is an appropriate measure of the court to uphold its duty under Shepherd, Nebraska Press Association, and the like, to preserve the right to a fair and impartial trial. At a minimum, Mr. Gray's statements that he's not bound by trial publicity rules or 3.6 in this case illustrate why the order of the court is necessary in this matter. And so we would ask that the court uphold the amended non-dissemination order, or at most tailor it to those statements specifically precluded in Rule of Professional Conduct 3.8. With that, I'll stand for questions.
Thank you, Mr. Redley. Yeah, do you think that would be helpful to just, and I asked Mr. Gray this same question, would it be helpful to say, okay, you can say these things, but you can't say these things, and be more specific about that?
Your Honor, our initial position is that the total prohibition of extrajudicial statements is the...
Yes, the prohibition of extrajudicial statements of the parties. Even the witnesses can talk. Did you guys hear that? I don't know if you realize that, but part of their argument from Shannon Gray was, wait a minute, the witnesses are allowed to talk, but I'm not allowed to talk on behalf of my client? But for some reason, they're not allowed to talk as witnesses.
The safest and most responsive way in this case to address and preserve the right to a fair and impartial trial.
Right. Can you go back? You mentioned this about the standard particularly applying to the lawyers who are somehow connected with the case.
Yes, Your Honor. In Nebraska Press Association v. Stewart, it's noted that the
oh my gosh, Nebraska v. Stewart. This thing right here. This thing right here. Look what we got. Look what we got. Oral arguments from that very case.
You'll hear arguments next in 75-817, Nebraska Press Association and others against Stewart.
Yes. Yes, thank you. Thank you for bringing that up, you young grasshopper. We're going to educate our audience. Thank you, Judge, for giving me that great idea.
I believe Justice Brennan states that there's no doubt that the court has authority, though it's in a footnote, it's no doubt that the court has authority to regulate the speech of attorneys, witnesses, and other participants in the court process. At this point, the evidence that's been provided is that the family would be potential witnesses in the case, as Mr. Thompson mentioned. We haven't necessarily been able to make a full assessment of that.
All right, I'm just going to stop. I hear people saying thank you for new memberships and stuff, and I haven't looked at the sponsors for this show today. So we have just for a little break to honor the people here on the channel. Thunder Granny Wolf, 8-month member. Andra, you look gorgeous. Happy Sunday. Well, thank you. Thank you. I was going for the gorgeous look. I have to be honest with you. I was trying to go with the tomboy, like beach wear, gorgeous, happy Saturday look. Did I pull it off? Stuffers, why I love BHB, is laying it down and letting us know these people are stomping on American rights. Yeah, the same people that swore to uphold the law. And you know what? With this judge, I think it's more, well, I think it has a lot to do. I'm looking at at him, and I'm trying to, he seems like, I mean, when I look at him and I've listened to him talk, like he seems like a nice guy. Like, he seems like a very knowledgeable man. It seems like he's really trying to do this the right way. I think he's just scared of making a mistake. I think he's scared of making a mistake in the public, in the light. I think he's nervous about this case. I mean, this case is a big case. It could make a lot of people very nervous. And I think that is potentially some of the issues that may be going on here. And the fact that he's relying on the prosecution. Usually, you can rely on the prosecution and defense to give you a fair, balanced approach to this. But here you've got them both siding with one another. And then you've got this attorney that's saying, hey, you're stepping all over me and my client's rights over here. And it's not, nobody's liking that. Everybody wants everybody just to sit down and shut up and let them carry this case on. But that's not how it's going to be. And, I just feel like this judge is relying on people that are going to be dubious to him intentionally or unintentionally because of their bias in this argument. And he's relying on them. He's putting a lot on the defense as well as the prosecution. And you got two that are basically arguing the same position against one attorney. So it's like they're almost badgering this other attorney, beating him over the head saying, sit down and shut up and let us handle this case. And it's like, and this judge doesn't seem like he wants to run this case the way the defense and the prosecution want to run it. They don't care, in my opinion, about the other stuff, and they need to be caring about the other stuff, the stuff that like the press, the stuff related to me, the stuff that you guys get to see. It's just one-sided here, and there's only a few people arguing the true problems with all of this, and that's the constitutionality of it, not whether the parties agree. It's whether it's constitutionally sound, and it's not. It's not.
But undoubtedly they'd be witnesses in any sentencing.
And what about the standard? Strict scrutiny or lower standard?
Your Honor, we would argue that the court should apply the standard in Gentile versus State Bar of Nevada, where the Supreme Court stated that, I don't want to mess this up, so I'm going to click here.
That's fine.
That the speech of lawyers may be regulated under a less demanding standard. So we would argue that so long as the court finds that it has a duty under Shepard to preserve the right to a fair and impartial trial, that the order responds.
I know what this guy lacks. I know what it is now. I couldn't put my finger on it, but I figured it out. Confidence. He's lacking confidence in his arguments. That's why he sounds so robotic. It doesn't sound robotic. You know what I mean? But he seems like he lacks confidence in his knowledge of these things. That's what I couldn't put my finger on it. There was something with this attorney, and I couldn't. Like, you can tell he's green, and if he's not green, oh boy. The best advice I can give this man is mirror and practice. Mirror and practice. Look at your body language. Look at your facial expressions, and recorder. You need those things. This man needs a lot of help here. This is not going to be good for his behavior, his speech pattern, everything to me is going to be distracting to the jury.
Addresses the substantial likelihood that pretrial, that negative pretrial publicity would have on that right, then the court would have authority to impose the amended non-dissemination order.
Thank you, Mr. Evans.
Thank you.
Judge, I think a lot has already been said, and obviously you wrote a lot in the briefing, so I guess I'll just touch on a couple of things. In terms of the argument that the victims' families are not involved in the litigation of this case, and therefore don't fall into 3.6, would be our position that if you have statutory and constitutional rights involved in this case.
Do you see the difference? Listen to this man talk. Let's just go back just a little bit. Hold on. I'm not going to torture you guys, okay? I'm not going to torture you guys. Oh, didn't go back far enough. Go back 15 more seconds. Here he is. Okay? We're going to listen to this, okay? And then we're going to speed forward 20 seconds.
Then the court would have authority to impose the amended non-dissemination order.
Okay, you hear that? Now listen to this.
A lot has already been said, and obviously you wrote a lot in the briefing, so I guess I'll just touch on a couple of things. In terms of the argument that the victims' families are not involved in the litigation of this case, and therefore don't fall into 3.6.
You see what I'm saying? Do you see what I'm saying? Second chair is going to be a distraction for the jury. He's not confident. He needs a lot of practice. Hold on, guys. I don't know if somebody's not. I'm going to keep playing this. I don't know if somebody's knocking at my door, if that's the neighbor pounding on something.
Would be our position that if you have statutory and constitutional rights involved in this case, you're involved in the litigation. Regardless of whether or not the prosecution is willing to work closely with you or whatever issue you have there, the reality is if you have literal rights that permit you certain things that are involved in this case, you're involved in litigation. And therefore you fall within 3.6 just like everyone else. Second, the standard from Gentile
neighbor working on the car.
Substantial likelihood of material prejudice. I don't want to get too much into that, Judge. I think that's kind of this afternoon's argument. I think the main thing before the court, as far as Mr. Gray and the family, is just do they fall within this, and then the court to decide what is appropriate. But I would note that given the vast amount of media coverage in this case, the fact that it seems like no matter what anybody says or does, in one way, shape, or form, it will be twisted into an attack on the client. We also agree that at this point, the safest thing to do is for everyone to just not.
You know what? I almost want to put a poll. I almost want to put a poll in the chat to ask how many people honestly believe that this non-dissemination order is going to stop people from talking smack about Brian Coburger. How many people, right? I mean, like, seriously, how many people honestly believe that this non-dissemination order is going to prevent people from talking smack about Brian Coburger? Like, is this court living in a fantasy world or something? Like, I don't get it. I just don't get it. Am I wrong? Am I wrong here? The haters are going to try to say I'm wrong, right? But does it make? I mean, we all know who all the key players are. It's like, oh, they're still using DM. Like, really? Like, the only people that don't know who DM is are people that have been living under a rock for the last, I don't know, 8 months. I mean, like, seriously. I'm going to be up here madly talking smack about this guy because I truly believe this man is guilty, and there is no court in this freaking free world that's going to shut my mouth when it comes to this. Absolutely not. Absolutely not. We have a right to discuss. We have a right to say he's the most horrible person in the entire world, right? That is our opinion. We are entitled to those. Those are something that the courts can't take away from the majority of us. Now, granted, the courts do have, I mean, and, you know, realistically, I know I put a lot of satire in some of this stuff, but realistically, the judge has a right to control what comes out of you. So see those people at that desk? He has every right to control those people. He has every right to control what is being disseminated from, say, law enforcement, the investigators in the case, right? But he can't prevent from people from putting hypotheticals together, talking about perspective, getting people like, say, retired FBI agents or forensic psychologists to come on their panel to discuss some of the questions many of the audience have. They cannot prevent that from happening. Even in the current non-dissemination order, we saw the articles that were written in with that non-dissemination order in place. It didn't prevent them from telling their perspective. The judge can't hold those people in contempt under this. Why? Why can't he hold them? Because he has no jurisdiction over them. That's why he can't hold these people in contempt. Out of all those articles, we didn't read one thing that said the prosecution said, the defense said, the investigator to the case said. This is stuff that they went out and hit the pavement and found other people on the outside of them and wrote these articles, and they are allowed to do that. And guess what? It happened under the current non-dissemination order. So Dolly is canceling. He just said it. Yeah, I went ahead and canceled my room. I've already let the people that I knew, because I don't want to say what audience member, but me and one of the other audience members in here were going to be meeting there. So Illinois newspaper. I don't know what you mean by yes, he can. He could not prevent me from speaking. That man right there in that courtroom, that judge, he can't tell me what I'm allowed to write, what I'm allowed to think, what I'm allowed to get. He can prevent the people of this case, the people he has jurisdiction over. Okay? Understand that. The law is the law. He must establish jurisdiction, much like the Supreme Court. And the people he has jurisdiction over are those people that are in that courtroom. Okay? He has no jurisdiction over me. He has no jurisdiction over the media. He has no jurisdiction over what he is allowed to let them say or not. He has no jurisdiction, and no, he doesn't. Let's be very clear about that. No, he doesn't. So, unfortunately, we're going to educate people here. We're not going to allow the uneducated to educate. We're going to educate people here.
Talking to the media and allow statements to be made here where we all get a chance to speak. You know, the media gets all that information. If they still choose to do what it is they've been doing, then that's on them. But we don't have somebody who's trying to put the media into a frenzy and send this case to firing squad or others. So
there's that firing squad comment.
The only other thing that I wanted to address in the court address.
There's that firing squad comment.
Don't have somebody who's trying to put the media into a frenzy and send this case to firing squad.
And quite frankly, he doesn't seem very convincing in his arguments. You would think something like that, he would have put a little more passion and emphasis behind it, in all fairness.
So that's our main concern. The only other thing that I wanted to address, and the court addressed this a little bit, the reason we stand silent with grand jury indictments is because there's an old arcane rule that says,
Oh, and the whole standing silent thing, guess what, Judge? If that non-dissemination order wasn't in place, they would have been able to tell it, and there wouldn't have been a week discussing it. It would have been done and over with. They would have walked out of the courtroom and said, yeah, we stood silent for this reason, and they went on their way, and it would have killed everything. But because of the non-dissemination order, people speculated for weeks, right? On what it meant. Way to go. I'm sorry. I just don't see how they don't get it. Like, they're the reason for the whole non-dissemination mess.
that if you have a grand jury indictment and you enter a plea, you are accepting the validity of the indictment. I haven't seen a prosecutor try to use that in a long time, but we can avoid any possible claims that somehow we can't challenge anything with the indictment by simply standing silent and having the court enter the plea. So just so that everybody's clear, that's why we do that. Does the court have any questions for me?
I think it's somewhere in the middle, personally, Allie. I think that's too far back. You know what I think it is? I think Brian had, because he studied BTK, he had to have studied BTK almost intimately under Catherine Ramsland's class, because that was the most notable serial killer that she really had the opportunity to get, that was so notable that she's being talked about today because of BTK. So he had to have more of an intimate knowledge of BTK than anybody else that learns about serial killers, that only Dr. Catherine Ramsland can provide them. And so we know BTK stood silent. And I'm wondering if, because of his knowledge of the case and because that was the reason that BTK stood silent, could he have potentially recommended it or decided to discuss it with his attorney that ended up ultimately being the route that they took? Who came up with this theory is my question. We'll never know. We'll never know. But I truly believe that it was due to the knowledge Brian Coburger has of BTK and the legal reasoning behind why BTK chose to stand silent. Could be wrong. Just my opinion, my perspective.
Thank you for that additional education.
Thank you.
All right, Mr. Gray, it's your motion, so you can respond to what other counsel express.
I guess the first thing I would want to address is the prosecution's idea that I haven't allowed our clients to speak with the investigators. You'll realize that the date of the incident, I wasn't retained on this case until close to December 5th, which will be more than 3 weeks after the incident occurred. And they still have made no contact as far as investigating and interviewing the victim's families. So somehow that I precluded that in some way is just not true, Your Honor. And as far as scheduling those things, I'll just leave it at that. The second part is everyone is quoting the Gentile case. The Gentile case is exactly like all of the other cases. It says over and over, it has to be a lawyer participating in the judicial proceedings. It has to be a lawyer who represents a defendant involved with the criminal justice system, a lawyer actively participating in trial, a lawyer who's participating before the courts can only be limited if he's participating in front of the courts.
The reason why he's going over this jargon about participation in court is because he's a victim's attorney. He's not participating in any of these legal proceedings. He's showing the judge by case law that he has no jurisdiction over him?
None of it applies to me
It seems like you're in court right now.
because you're the one that brought me in here because of the non-dissemination
You
order.
brought yourself.
Yeah, well,
You're the one who filed the motion.
I did file a motion because the non-dissemination order is unconstitutional.
I'm just trying to clarify what you just said.
Well, this will probably be the only time I'm allowed, because I won't have the authority to file any other motions on anything else in this case.
Why
Because,
would you say that?
well, because I'm not a party to the case.
You can still, I mean, the media is not a party of the case either.
Once
But
again,
well, the Supreme Court has said they have standing to come into the court and address issues. So,
yeah, but that's completely separate. They're not.
well, I know it's separate.
Okay, so.
I also respect your position in representing the family's victim, the family's victim, or, excuse me, the victim's family, and I respect that. And there are some constitutional issues, rights that they have. So I'm not just dismissing that.
And the mere fact that you have a right, I'm absolutely positive that the Idaho legislature and the Constitution, when they gave victims rights, didn't think that that was implementing those victims into the trial in some way. Absolutely positive that wasn't the intention of it.
Totally agree with that.
So this idea that if you have rights, then you're involved is just beyond. That being said, Your Honor, nothing precluded the prosecution from contacting my clients well before I was representing them. I had almost 3 weeks to contact them. I think, don't mark me on this, I think I was retained on December 5th. I think that was the day. I don't have my file in front of me, but it will hold me to it. But I think that was the day. So they had plenty of time to contact my clients and interview them if they were going to be potential witnesses in this case.
He's making a valid point.
Every time we have had a meeting, we have initiated that conversation. It hasn't been the prosecution initiating that conversation.
So are you saying since you have been representing your clients that the prosecutor or investigators have not asked for interviews?
I would say this, in the meetings that I have had with the prosecution's office, I have asked as part of that whether interviewing my clients might be an issue. Would they like to do that in some way? I've offered that up in some way, and they've never taken us up on it. And maybe a random email here and there that says something and no follow-up whatsoever about it. So this idea that they are going to be witnesses in this case is just an attempt by the prosecution to shut them up as well as to shut me up. And by the way, people completely forget about this. All of the information that has been disseminated to the public from the get-go was the mayor, Art Betke. Chief Fry had interviews. Bill Thompson had interviews. The coroner had interviews. All of those people had interviews. We didn't until we started getting information and started trying to figure out what was going on after they had given interview after interview after interview. That was the purpose of the judge issuing the non-dissemination order, is to quiet them up, not quiet the victims up. They had no control over that investigation from the get-go.
Well, that order was a stipulation between
That's
the state and Mr. Coburger.
That's the other thing, though, is that the court, after that Zoom meeting, Judge Marshall incorrectly said that that was stipulated by all parties. I never stipulated to that. I emailed the
You're
judge.
not a party.
Exactly right. I'm not involved in the
The
case.
stipulation was between the parties.
So-
As you correctly stated who the parties are.
So we would ask.
I agree, but you were suggesting that it was entered to shut down the prosecutor's office.
Why would they?
That's what you just said.
I do think that part of the that was part of the process, is that they understood that their investigation was getting out of hand. Too many people were talking in their investigation, and that's why they stipulated to it. Yes, I do.
Okay, when you say they, you mean the prosecutor's
Yes.
office.
Yes.
All right.
Do you want me to give you a final, or do you?
Go fight
Okay,
it. You go.
We're not a party to the case. You're very aware of that. I have the right to repeat what my clients say to the media. I also have an independent right governed by the Idaho Rules of Professional Conduct regarding those individual rights versus my own opinions. But those opinions, I don't firmly believe, would fall under the publicity rule on the Idaho Rules of Professional Conduct, because I'm not litigating it or party to the litigation. And the reason those things are in place are because people that have real privy information regarding the prosecution and the defense, which I don't, which my clients don't in any way, it shouldn't apply, Your Honor. Thank you.
Okay, thank you, Mr. Green. All right, well, I'm not going to issue a decision today. I'm going to issue a written decision. There is a lot of briefing, and I heard some very interesting argument today, and I'll get that to work. And
Interesting is an understatement.
As soon as possible. So, anything else we need to address before I adjourn? Mr. Thompson?
I don't think so, Your Honor.
Ms. Taylor? Mr. Washington? Anything?
We thought you'd probably want to issue an order and wait, but I guess we're just wondering if in the meantime, the order as it is remains in place.
Yes.
Thank you.
It remains in place until I address it. So, with that, we are adjourned. Thank you all.
It remains in place until I'm sorry. It's just, I don't know. It just seems really lopsided. It really does. I'm hoping the judge, I think the judge he's gonna review the law, and I think he's gonna listen to the arguments. I think Shannon did a great job at basically separating them from the case, in my opinion, separating themselves so much so that he's made it, like I said, look as an unprecedented ruling of controlling victims' families. I think it's awful. I just think it's awful. Tomorrow, we're going to learn a little bit about Nebraska Press Association versus Stewart. We hear a lot about it in these cases. It's brought up as it's a benchmark ruling that is used in a lot of pleadings when arguing about these types of things. So I think it's good in an effort to educate the audience. We are going to go over that Nebraska argument and ruling. So tomorrow, stay tuned for that. And we've got a few other things that we will be going over and updating you guys on. There's a lot more pleadings that have been published on the docket. We'll be going over those first thing in the morning. We're going to do, don't worry, I've got an alarm this time. I got an alarm stuffers. I got an alarm. Actually, let me make sure I got the alarm. I'm eating gummy bears. I'm having like a freaking sugar attack. Oh my God. 11. Repeat never. Alarm stuffers live at 11. I'll put that at first. Actually, I probably shouldn't put it at 11 because that's when we need to be there. 10:30. All right. And that's for tomorrow. Awesome. You are officially on. You got a notification. Like my alarm will go off. It's going to, right? Anyways, so tomorrow, how it's going to work, we're going to have our live here. We're going to break from live. We're going to go to church. From church, we're going to go over to Steffers. So you guys are stuck with me half the day if you want to follow me around. Let's go make our rounds. But you guys have had enough of me today. It's Saturday. You've already had 3 hours and 14 minutes of me. I want to wish you guys the best weekend possible. I love each and every one of you. I want you to be safe. I want you to enjoy yourself and enjoy the beautiful weather. I hear people talking about how hot it's getting. It's summer, folks. Time to get those beach clothes on and head to the lake. Have a great day and God bless.
As you wake up in the morning, you want to find the latest, greatest information about criminal cases and have an intuitive conversation about the suspects associated with these cases. Head over to the Bullhorn Betty channel on YouTube. Get breaking news right here on the Bullhorn Betty channel. Welcome to the Bullhorn Betty Coffee Club. Enjoy your stay and enjoy your day.